Namaste and greetings. I, Naina Agarwal, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti, Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI Web Policy Learning. Today, we are gathered here for day 2 of a 3-day immersive online legal awareness and certificate training program on reproductive and conjugal rights of women in India. This training program is organized by IMPRI Gender Impact Studies Center, GISC, New Delhi. I welcome all of you to this enlightening deliberation and thank you for being interested and putting your time, energy, and efforts into understanding emerging issues considering the impact of policies in promoting gender equality, women empowerment, and accentuating legal awareness, and thus helping us to bring together the practitioners and participants through this course for impactful policy research and action. This session will be chaired by Professor Vibhuti Patel, Visiting Distinguished Professor, IMPRI. Our convener is Dr. Simi Mehta, CEO and Editorial Director, IMPRI. This 3-day training program has an excellent panel of members who will be sharing knowledge on the above theme. The distinguished panel of members for this program are Professor Dr. Saumya Uma, Advocate Dr. Albertina Almeida, Dr. Amar Jesani, Advocate Dr. Shalu Nigam, Professor Vijay Lakshmi Nanda, Professor Veena Vaswani, Professor Mala Ramanathan, Advocate Audrey D. Mello, Advocate Mrunalini Deshmukh. Before starting today's session, I would like to announce the housekeeping announcement once again. Please join the meeting on time. There will be a Q&A session after each presentation. Share your question on the Q&A box and not on the chat box. The question must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making any general comment in the question to save time. Now, without any further ado, I would like to invite Professor Vibhuti Patel to start the session with her opening remarks and start with our expert session. Looking forward to our esteemed gathering. Over to you, ma'am.
Yeah. Thank you, Naina. First of all, I would like to once again thank Dr. Arjun Kumar, Dr. Simi Mehta, Naina Agarwal, and Ms. Fiza Majid for their hard work in preparation for this immersive course. Yesterday's recap, I think yesterday we had 4 speakers, and the first one, Dr. Veena Vaswani, she gave us an overview of the public health system and how it is responding to the reproductive health challenges. We also had a second speaker spoke on the living relationship and the challenges faced by the couples, as well as community response and the way legal system has been changing its attitude towards this relationship, intimate relationship outside the gambit of marriage, and also the question of domestic violence and the rights of the partners, they were also being discussed. The third presentation was about the question of by Dr. Mala Ramanathan, dealt with the whole history of reproductive rights movement globally, starting with ICP, starting with the India's family planning policy, the excesses imposed during the emergency rule and the human miseries, ICPD, paradigm shift from reproductive control to reproductive rights. And she also gave a long list of recommendations and the future course that we can take. And the last presentation by Professor Vijaya Lakshmi Nanda, it also started with the macro analysis of the new reproductive health new reproductive technologies. And she gave an in-depth case study of Preconception and Prenatal Diagnostic Techniques Act, its genesis, the campaign done by the women's rights movement, the challenges that have come up, and also she connected it to the world economy and the neoliberal paradigm in which the pharma industries and the new reproductive technologies operate. All of them gave a very doable agenda that we can take ahead in this area of reproductive and conjugal rights in India. Today's presentation are focusing on the law and reality of women and the girls facing sexual and domestic violence by Advocate Audrey DeMello. And Dr. Amar Jisani's presentation is on role of health workers in assisting survivors of sexual violence. Now, it is very important to understand that the women and girls have the right to decide freely and responsibly in number, spacing, and timing of their children as per the law. They should have information and means to decide freely and responsibly to take decision about their personal life, attain highest standards of sexual and reproductive health. It's very important. It is an important agenda put forward by World Health Organization and the Women's Reproductive Rights Movement, and to make decision about reproduction free of discrimination, coercion, and violence. So it is very important to see the whole issue of women's movement's role in reproductive health movement from this broader perspective. Right to equality in reproductive decision, that means right to equality in reproductive decision include choose whether and when to marry and start a family. Child sexual abuse or child marriages, they are crimes as per the law, but they are still prevalent world over and in our country, and in the context of pandemic, they have even increased due to the poverty and deprivation faced by the large majority of population. Marriage should be with full, free and informed consent for both individuals, which is still a dream, which is still an unrealizable mandate for majority of women and girls. Women have a right to make responsible right choice for reproductive decision. There too, most of the studies, including National Family Health surveys, Survey 1 conducted in 1999-2000, Survey 2, 2004-5, NFHS 3, 2007-8, NFHS 4, 2011-12, and current NFHS 5, 2019-20, all of them show that women have a very limited autonomy so far as the reproductive decisions are concerned. When we talk about the right to sexual and reproductive security, the life of free of gender-based violence becomes very important. So violence in the family, incest, trafficking, dowry-related violence, rape based on the fact that you are a woman, protection of physical and mental integrity, that is also not provided or not ensured for large majority of women, because psychological and emotional violence is also the currently, if you see, the Oxford Dictionary has said that, declared that this year the highest number of clicks were for the word called gaslighting. So gaslighting is happening in a big way. Management and gynecological problems and the infertility prevention, even there it's a very, very complicated area where the rights of the surrogates or rights of the person who is renting her womb, they are not respected. Treatment and prevention of sexually transmitted diseases and sexually transmitted infections, there too we see a strong gender bias. If a man has HIV, AIDS or a sexually transmitted diseases, he will be looked after by the family. But if a woman gets it, then she gets social rejection. She's outcast and she faces total social stigma and isolation. The highest incidence of sexually transmitted diseases, infections, they reflect the practice of unsafe sex. And that is because of the subordinate position of women and transgender community in our society. When it comes to right to reproductive and sexual health services, we know that the safe and affordable methods of family planning, yesterday's presentations after presentation, right from Dr. Veena Vaswani's presentation to Mala Ramnathan's presentation, they all, and even Dr. Vijay Lakshmi Nanda's presentation also showed that safe and affordable method of family planning are still not available to large majority of women in reproductive age. Even when women decide to have children, they don't deliver the baby in a safe environment with medical care and assistance. So unsafe deliveries are taking place because only around 52% of pregnant women have access to medically competent persons as a caregiver. Women use family planning services, that too, safe and hygienic environment is not provided. Most of the time, women have to opt for they're straight with whether it is a permanent method or a barrier method, women don't have a choice. So here, the question of safe motherhood or right to survive in a pregnancy becomes very important challenges. The presentation by Dr. Amar Jisani about the healthcare workers, I think there also very scant literature is available, except for the Women's Association or the trade unions. Not much work has happened in the area of condition of auxiliary nurses, midwives, ASHA and Anganwadi workers. The promotion of the rights of these workers is a fundamental basis for government and community-sponsored policies and programs. The government must consider rights as a fundamental part of the laws it enacts and also policies it puts in place and the program it creates. Treatment of women, especially those from marginalized sections at the public health facilities, is often inadequate, indifferent, callous, and stripping them of their bodily integrity, dignity, and agency. Nobody even bothers to see what are their perceptions, what do they want. So there is a big gap between what women want and what women get. This results in women's reluctance to seek treatment at the public health facilities, thus impacting their access and also reach. So upholding of reproductive rights and provisions of sexual and reproductive health services are essential to protect human rights of women, particularly those belonging to the marginalized and excluded groups like sex workers, LGBTQIA, lesbian, gays, bisexual, transgender, intersex, queer, and questioning groups, and women with disabilities and aging women. Another most important and neglected area is that of a girl child. Now the age at menstruation has gone down. Girls, even in the 5th and 6th standard, they start menstruating. What about their reproductive health care? What about and I think the issues which Audrey is going to discuss, I think that is also extremely important in the context of the recent changes in the MTP Act, about which yesterday Dr. Mala Ramnathan also talked about us. So with this background, I think my first presentation is mine, that is about women's movement and the reproductive health concerns of the taken up by the women's rights movement. I have my PPT. 1 minute. Yeah.
Meanwhile, Nana, you can.
I need to share the screen. Yeah.
I would like to introduce our first expert for today's session, Professor Vibhuti Patel. Professor Patel is visiting Distinguished Professor, IMPRI, and ma'am's topic is Reproductive Rights of Women in India. Very warm welcome, ma'am, and over to you.
Thank you very much. Yeah. Thank you, Naina. 1 minute. I'm. Is it visible? My PPT? Is
Yes.
my PPT visible?
Yes.
Yeah. So it was in 1993 that the women's movement world over declared that reproductive rights of women are human rights. So it has to be treated in the context of the overarching concern of human rights. Now, when we talk about reproductive rights of women, I would like to reiterate, and I think it came up yesterday also, that what do we mean by reproductive rights? It's the ability to reproduce, which seems to be what sets women apart from men. Do women have control over their own reproduction? Do women have freedom to choose whether, when, and how many children to have? Do women have access to safe birth control methods? Do women have right to safe abortion? Can sexuality be separated from reproduction? A big no is in answer to many of such questions led to emergence of women's health movement world over and in our country. Now, what we see is that it started as a small consciousness raising groups, which began by spreading awareness among women about functioning of their bodies and gradually evolved into multifaceted campaigns that have significantly influenced health policies in many countries. When we talk about the reproductive control, because that we are against reproductive control, but what do we mean by that? Control over women's bodies and sexuality. If a husband forces himself to have sex it starts with that, her husband forcing his wife to have sex, to a government forcing a woman to undergo sterilization. That happened, all of us still have a very, very painful memories of what happened during those 18 months of emergency. It critiqued the institutionalization of patriarchal control over women's sexuality in the form of monoandrous heterosexual marriage. That's you have marriage only with your husband. It challenged the predominant social norm of patrilineage, inheriting from father's side that only offers stamp of legitimacy to the legitimate heir, and severely punishes sexual expression or reproduction outside marriage. That means this whole quote unquote illegitimate child, even that concept was challenged by the women's rights movement. Within the framework of the existing thinking, what we see that the state of complete physical, mental, and social well-being, which would consider as a health, not merely absence of disease or infirmity. That's how the World Health Organization has defined health. Reproductive health addresses the reproductive processes, functions, system at all stages in life, which is physical well-being, infirmity, processes, and life. So today you are able-bodied, you are active. Tomorrow you may develop some infirmity, either due to age or due to heart condition, due to diabetes, whatever. But you still have a right to have the same kind of indulgence and care from the state and the society. When a woman doesn't have bodily integrity, when her body is invaded against her will, when her choices are determined by social norms rather than personal preference, it is unlikely that she can play an active role in the decision making, be it at the micro household level or a macro society level. In an attempt to reclaim women's control over their own fertility and open avenues for autonomy and decision making in other aspects of life, the women's health movement all over the world has defended women's rights to voluntary maternity through access to safe contraception and abortion services. This struggle for women's reproductive rights has resulted in right to contraception being conceded in many parts of the world, although women still lack easy access to affordable contraceptives which are free from side effects. Even today, these services are denied to women in many, many parts of the world. Reproductive control over women in India, when we talk about this, we have to first and foremost, the question that bothers us is child marriages. Currently also more than 1/5 of the girls are married before they attain their majority. That means now it is 21, which before, below 21, it is considered as a child marriage as per the recently enacted law. The myths about menstruation, the whole question of purity and pollution that Indian mindset has because of the caste system. So menstruating women are considered to be ritually polluted. Dropout of girls from school that happens because of after menstruation, because there is no facility for menstrual hygiene in most of the schools. Religious and cultural taboos prevent women from using contraception. In cultures such as India, where motherhood is glorified and infertility viewed as a curse, the use of contraception is also frowned upon. Now that this, after 75 years of continuous propaganda by the family planning authorities, some change has come. But still we have 300 blocks in the country where TFR, total fertility rate, is more than 3. But still, like nearly 20 states are below stabilization. So couples are producing less than 2 children, or there are DINK families where double income, no children. Families are also increasing in the metropolis. 30 years after it began, the struggle for women's control over their own fertility has led to a separation between sexuality and reproduction, where women are able to exercise their sexuality without pregnancy being the inevitable result. There are important ethical concerns when we talk about the control, reproductive control. That is, one is bodily integrity, dignity of women, informed consent, and the state policies of incentives and disincentives. Those who are, like we know yesterday also we discussed that so many states have imposed 2-child norm. And Dr. Vijayalakshmi gave a case study of a lady in Orissa, where she has more than 2 children and she's not allowed to contest election. There are so many other penalties also that some states have in terms of ability to access anti-poverty programs or ability to access or promotion if you are a government employee. All these penalties are also abhorred by women's movement. Now, the political understanding of this, that in a situation where women have no right to clean drinking water, basic facilities, healthcare or education, where society decides where woman will live. After marriage, where will she go? She will have to go, because if you see the migration data, 85% of Indian women are shown as migrant workers. How come? Because after marriage, they go to other place. How do they they will leave? Okay, whether they will leave or die, who they will marry, whether they will study, where the state, the international development and aid agencies believe they have the right to determine how many children women will bear. It is the state which decides, because family planning policy. Where is women's agency? You should. I also request you to watch movie, documentary by a very good documentary, Something Like War. It's a which shows the whole history of family planning program in our country. It is produced by BBC. Deepa Dhanraj has made this film. It's a very well-researched film made in collaboration with several women's organizations in the women's health movement. When they will get sterilized, what form of contraception women must adopt? Important pillars of reproductive health are reproductive freedom, reproductive choice, pregnancy-related care, and freedom from violence. These 4 pillars, they have to be really strong. They have to be really robust. Then only women can enjoy their reproductive rights. Now, reproductive rights of persons with disability. For the first time in last 5-6 years, we are seeing that the women with disabilities, they have now started getting heard. They are getting platforms. They have and they also have their association. United Nations Convention on Rights of Persons with Disability also recognizes reproductive rights of persons with disability. At the same time, our own law, which is also inspired by UNCRPD, Rights of Persons with Disabilities, 2016 has taken cognizance of this. Population control policies, there is severe criticism, and the attention to the population control policies and the nefarious activities of the local vested interests who are having who have obsession about the targets to reduce birth rate. They also create so many human miseries. Last thing we heard was in Chhattisgarh, how more than 121 tribal women died because the sterilization operations were conducted on them without any examination, and the post-operative care was not taken. Most of them died due to septicemia. And that was a very big Samahed, and the Janaswasthya Abhiyan had also organized the investigation, and they came out with the report. It is there in the public domain. Now, when we talk about the birth control, as I told yesterday also, that individual woman's right to control her fertility, at most couples attempt to determine family size, while family planning or population control is a government or the state's attempt to limit the number of its citizens. This fundamental difference manifests itself as the difference between women's overall health, their reproductive role, individual life choices, national goals, personal empowerment, coercive government sterilization program, and policies that trample upon individuals' right to birth control in national pursuit of limiting population. In the other side of the coin is pro-natalist policy. We have so many tribes which are declared as endangered tribes. And in those tribes, women are not allowed to use any contraception. They are not even allowed to take. There is so much of poverty, deprivation, hunger. There is one woman, she said that she has produced 16 children. She has nothing to feed to them. But whenever she goes to family planning center, she is told that her tribe is not allowed to control population. So even when there is a pro-natalist policy, women are used only as a vessel to produce babies. They are used as baby machines. In a sex selective, in a son preference mindset, women are used as a son producing machine. We have countries which are declared as pro-natalist countries, whole of East Europe or White Russia, or in France for French people, wherever they think that their population is reducing. And you know, the East Europe and Russia, they faced more than 30, 40 years of continuous war and civil war, right from 1905 to 1940. They had a continuous volatile political situation. So many men died in those wars and civil wars, and the population, the sex ratio is in favor of women. But there are the population, white Russian population was facing decline. And that is the time they said that they took away the abortion services, reproductive health services from the country's national population program. And women were asked to produce more and more babies as a patriotic duty for the country. So imagine, whether you are a pro-natalist or anti-natalist, none of them have any respect for women's choice, women's bodily integrity, and women's even health status. As I told you, in those tribal women, they themselves are anemic. They are completely famished, and still they are made to produce babies. Now, coming the women's health movement has taken up right from the 70s. N number of issues were taken up by them. It started with the busting the myths regarding menstruation. They also talked about the problem, critical evaluation of the contraceptive methods. How many of them are hazardous to women? What are the contradictions of various or contraindications of various contraceptive methods, whether they are invasive methods or where they are hormone-based drugs? They created awareness about the bodies, women's bodies, so that we don't be ashamed of our body. Women's body, early discrimination, which results in malnutrition. That the question of nutrition was also taken up by women's movement. Why Indian women are made to eat last, list, and leftover. Cultural and religious taboos about menstruation, about pregnancy, about childbirth were thrown to the winds, and issues brought out in open. Over medicalization of pregnancy among the people who have a purchasing power, those who are middle class and rich, for there you see over medicalization, childbirth for higher classes of women, and also manifested by unnecessary cesarean section. Mala Ramanathan has done a massive study of in how many the percentage of women who could have produced children through normal process. They were nudged, or they were motivated to go for the cesarean section, which is over medicalization. There are so many scams in different parts of India which have been periodically portrayed in the newspapers, and so many reports have come up about the malpractice, medical malpractice and over medicalization. Women's health movement also reiterated slogan of the feminist movement: personal is political. That means you can't separate women's health problems as a personal problem and just put it under the carpet. So it is, these are the social issues, these are the public health issues, and they have to be taken up. You can't put the onus on individual women. Now, long-acting hazardous contraceptives have been always a major bone of contention so far as the feminist movement is concerned. Hormonal contraceptives like injectables such as EPA, estrogen progesterone drugs, NET-ON, Depo-Provera, implants such as Norplant, nasal spray, abortion pill RU486, which is an emergency abortion pill with all of them have a different combinations of estrogen and progesterone. They can play havoc with the system of health system of women. They can also create so many side effects are there. It can be disproportionate weight gain, or women growing, they would get beard, or there would be other effect on their eyesight. They may get migraine. There have been reported cases of carcinoma of uterus, carcinoma of cervix, breast cancer. They are also linked with that. So there is a lot of skepticism about this kind of hormone-based contraceptives. So many countries have outlawed these contraceptives. But when the new economic policies were imposed, stabilization policies were imposed to poor countries of Africa, Latin America, and Asia, they had to accept this package of, they would get aid from World Bank and International Monetary Fund only if they agreed to have population stabilization. And World Health Organization also at that time came up with a cafeteria approach. That means you can choose the methods of contraception, whether it is a barrier method like a diaphragm, or female condom, or a male condom, or you would go for a temporary method such as insertion of intrauterine device, or you would go for a permanent method of sterilization, and also hormone-based contraceptives with a reversal effect. Like once you stop using those anti-pregnancy vaccine or hormone-based contraceptives, after some time, your fertility may come back. But there have been n number of public interest litigations filed world over by the women's organizations. There was one highly controversial method of contraception that was a spiral. So that created lot of health hazards for women. So many women faced what you call uterine perforation. They faced septicemia, and many of them got compensation from the multinational pharmaceutical industries. In India, women's organizations, 6 women's organizations, they came together and filed public interest litigation against Depo-Provera, again the hormone-based oral contraceptive. There were agitation against NET-ON and also Norplant. Norplant was started by the doctors in Chile, and you know that Chile, after when the Pinochet, the military dictator, came to power, the first thing he wanted was a imposition of an extremely barbaric population control policy. So it is in this context that the Norplant was invented. In response to public interest litigations by women's organizations such as Saheli in Delhi, True in Baroda, Stri Shakti Sangatna in Hyderabad, Forum for Women and Health in Mumbai, and Vimochana in Bangalore, the government of India the Drug Controller of India also organized public hearings. So there have been public hearings, 4 public hearings to discuss where the pharma industry, the government officers, women's organizations, and those who were the victim of use of these hormone-based contraceptives, they made public submissions, which was a very important, or globally, Forum of Feminist International Network on reproductive rights and genetic engineering, that also took up this issue globally. In Bangladesh, we had a organization such as Nijera Kori or Ubinik. They had taken up these issues. In several East Asian countries also, women's movement had taken up this issue. So the research and documentation becomes very important. Many women scientists, women researchers, women study scholars, and women doctors, they also helped in getting accessing the research material to build the strong case, because you had to prove the point in front of the very articulate, heavily funded medical lobby and the scientific lobby. Community-based work is extremely important. In fact, now also in most of the community-based organizations, they have taken women's reproductive health in their topmost agenda. Legitimization of women's experience, the medical science and the science, it always goes for the abstractions and generalizations, but women's evidences, women's experiences are brushed aside as psychosomatic or just anecdotal work, which is women's movement and the feminism believes in respect and legitimization of women's experiences that they did. And the global networking that came as a result of FINRAGE. Now there is also PhD thesis on FINRAGE. The book has also come out on that issue, about the whole history of how feminist activists, researchers, scholars, scientists, and doctors, they came together to build this strong reproductive rights movement. Increasing male responsibility for contraception is another very important concern of the women's movement. The condom is a cheap, reliable, and easy to use barrier method with practically no side effects. It also provides necessary protection against sexually transmitted diseases and HIV/AIDS. So we saw that once the campaign against HIV/AIDS started, there was a resurgence of interest by the global funding institutions and global foundations on the condom. No, and they basically, it was through the red light areas and where the sex work is happening, they started popularizing it. Vasectomy, a male sterilization, is much simpler with a fewer complications than female sterilization, but the man's reluctance to undergo vasectomy leads to women having to take major responsibility for sterilization. At the same time, so many times even women themselves say that better sterilize me in case if I get pregnant. And my husband is sterilized, then everyone will cast aspersion, because so many times sterilization operations fail, no? So if the vasectomy fails, or after the male sterilization, 3-4 months, still for nearly 3 to 4 months, man produce sperms, no? So, and if a woman gets pregnant, then they would cast aspersion on her that she was not loyal to her husband and is someone else's child, and her child would be treated as an illegitimate children. So many times women also say that she would like to get sterilized. Overall change in man-woman relationship is essential, since it has been well established that women cannot gain control over their bodies in the context of unequal gender relationships. Yesterday's all 4 presentations brought out this kind of unequal power relationships in the intimate partner relationships is the major, is decisive force. Now, more than half of the abortions that take place in our country are unsafe. 10 women die due to unsafe abortions every day. Unsafe abortions cause 8% of maternal deaths in our country. This is according to the sample registration system of the government of India. So you can understand the enormity of the problem that women face because of unsafe abortion. Yesterday, also we have discussed this issue in great length. So Medical Termination of Pregnancy Act that was enacted in 1972, again got revised in 2021. Unsafe abortion is a major cause of death and health complications for women of childbearing age. Although it is difficult to get data on illegal abortion, it is estimated that worldwide, 1/3 of all abortions are illegal. 20 million unsafe abortions are performed annually. The estimates of number of women who die from unsafe abortions all over the world range from 70,000 to 2 lakhs each year. While fighting for women's rights to safe abortion, the women's movement has also cautioned women about dangers of repeated abortion. Whatever said and done, abortion is an invasive technology. Making safe, reliable contraceptives available to all women, including adolescents, would go a long way in reducing the need for abortion. Now, coming to the important concern that we have about the struggles to say reorient the scientific research, ethical and scientific research into the public arena, in terms of, say, whether it is a human trials, is there any informed consent? We saw massive violation of ethical concern during the pandemic, the COVID-related researches that were happening, even about the vaccine research, I think about which Dr. Amarjit Sani will tell you a lot. Fundamental questions regarding direction of medical research, especially the contraceptive research. Why all contraceptive researches are focused only on women? Why aren't we coming up with the safe contraception for contraceptive methods for men? And why don't we even do the public education of men that they also have a responsibility in terms of contraception? Pressing for pursuit of safer, non-invasive methods of contraception for both men and women are extremely important. A more women-oriented, pro-people perspective marked by healthy balance of societal needs and individual rights, the need of an hour, and community-based initiatives, they are the key to create this kind of a ecosystem. Self-help and fertility awareness in order to regain control over women's bodies, multifaceted attempts to evolve new and more sensitive approach to women's health and healthcare, rediscovering traditional and indigenous treatments and cures, and also redefining women's relationship with their bodies, I think is very important. And in the process, taking significant steps to crucially impact the control that patriarchy in society and the state has over their lives. So whatever patriarchy, they both are the same two sides of the same coin: patriarchal control on individual women and the patriarchal state's control on women in general. Now, coming to the recent last 50 years of work which the women's health movement has taken up, that is a new their understanding on new reproductive technologies. New reproductive technologies perform 4 types of function. One is assisted reproduction, that means in vitro fertilization, IVF, subsequent embryo transfer, gift gameta intra-fallopian transfer, ZIFT, cloning, assisted reproduction. So this is called feminist, like Krista from Germany, she has called it care extractivism. Contraceptive technologies prevent conception and birth. Amniocentesis, chorion villi biopsy, needling, ultrasound, imaging techniques, they are used for prenatal diagnosis, for identifying the 84 types of medical conditions of the fetus, but it also it is largely used for sex selection and resulting into sex selective abortions. At least in India, a lot of research and the campaigns have taken place, but most of the Asian countries and South Asian countries even more are using sex selective techniques for elimination of girl child, for a femicide. Gene technologies play a crucial role through genetic manipulation of animals and plant kingdom. And now the scientists have started experimenting these technologies even on the human beings. All these 4 types of new reproductive technologies, they are based on principle of selection and rejection. Now, when there is a racism, classism, caste-based discrimination in a society which is based on the where the neoliberal logic works, these kind of technologies under the commercial interest and racist, classist, patriarchal bias can play a havoc in the lives of women from the marginalized section. It can also who has a right to survive and who needs to be eliminated. Disability movement has asked this question that what do you think? Everyone is disabled. As Professor Anita Ghai says, all of us are disabled at one stage or the other of our life, either in a childhood or in a due to accident or in the later stage in life. So how can we just decide that this person this child has a right to be born and others don't have? So this is also a very important philosophical question. So the challenge to the prenatal sex determination. As unborn children, women face covert violence in terms of sex selection, overt violence in terms of female feticide. After the use of amniocentesis, chorion villi biopsy, sonography, ultrasound, and imaging techniques, in vitro fertilizing clinics for assisted reproduction are also approached by infertile couples to produce sons. Doctors like here we have in Mumbai, there are doctors who have put up their website with the aggressive advertisement. Invest 5 lakhs now, save 50 lakhs later. That means if you get rid of your daughter by using IVF and only produce a male child, you will not have to spend money on her dowry. No. So what we say so new reproductive technologies also need to be scrutinized through gender lens and its societal implications, and changing the mindset. Again, we come to the same issue of changing the mindset of son preference and aversion to daughter. Now, coming to the condition of health workers in the healthcare system, you know that the healthcare system also has a strong patriarchal model where the doctor is treated as a father figure, nurse is treated as a mother figure, patients are treated as a children, and the health workers who are at the bottom of the health system's pyramid, they are treated as subhumans. So that is why we see that so many mobilizations of ASHA workers have taken. If you see the responsibilities which these ASHA workers have, right from counseling to community sensitization to provision of drugs to community mobilization, survey of health and related, do the paperwork and diagnosis, basic like for malaria or pregnancy, acting as an escort to the antenatal and postnatal care or institutional delivery, immunization, diabetes, family planning, all this work which they are doing, but they are not treated as a worker. They are the they are the employees of the governor, but government, but they are not even getting the minimum wages stipulated by the state laws. They are only given mandan, they are given honorarium, and their workload is that of more than 12 hours. And we saw during the pandemic, they were working even for 16 hours. Nobody even maintained statistics that how many ASHA workers died while working as a corona warrior. They were not even given personal protection equipment. They were managing with their own mask and their own hand sterilizer. So reproductive health has been defined as a state in which people have ability to reproduce and regulate their fertility. Women are able to go through pregnancy and childbirth safely, and outcome of pregnancy is successful in terms of maternal and infant survival and well-being, and the couples are able to have sexual relations free of fear of pregnancy and of contracting any diseases. So with this understanding, we need to to take up our action agenda, and also wherever we are, whether we are in educational institution or a community or in a policy making bodies, and even in the budget making, because you know that in the gender responsive budgeting, 85% of the budgetary allocation are from RCH, reproductive and child health. So it's a very, very important concern, and that's why and women's movement, for them, it's a very important agenda. They work in collaboration with organizations such as Medico Friends Circle, Janaswasthya, People's Health Assembly, and Forum for Women in Health, and several other groups all over the country. These are some of the important references which I have used. CEDAW is very important. CEDAW has a section on reproductive health. We have a international conference on population and development, ICPD plus, which was discussed by Dr. Mala Ramanathan and Dr. Veena Vaswani yesterday. Then there are articles by the scholars. There is a ICPD also has a n number of documents, country-specific documents, as well as the global documents. Saheli's statement, Sahel is a collective product, that is the reproductive rights of women in Indian context, is extremely educative, and it is also there in public domain. Then Fourth World Conference on Women, Beijing Platform for Action, 1995, has taken serious cognizance of reproductive rights of women. And the World Conference of Human Rights in 1993, where the slogan "Women's rights are human rights and women's reproductive rights are human rights" was they were discussed, and the declaration and the program of action provides a guiding light for the future pathways in the direction of reproductive health guarantee for women of the world. Thank you very much.
Thank you so much, Professor Patel, for an enriching session and taking out time and giving us valuable information. Now, I would like to invite our second expert for today's session, Advocate Audrey D. Mello. Advocate D. Mello is Director, Majlis Legal Center, Mumbai. Ma'am's topic is the law and reality of women and girls facing sexual and domestic violence in India. Very warm welcome to you, ma'am, and over to you.
Thank you so much. It is always a pleasure to hear Vibhuti speak, and I am so delighted that I could attend this session. Just a brief introduction. I work with a center called Majlis, and we provide legal and social support to victims of domestic violence and rape. We've been working for the past 30 years, and we started by representing women in the family courts. And over the years, when the Domestic Violence Act came into being in 2005, we started representing them in cases in the magistrate courts. And in 2011, just before actually this very big case that kind of really put women's issues, especially the issue of rape, in a spotlight, the Nirbhaya case, we had prior to that started our intervention in rape cases to follow up rape cases in the criminal courts. So it's a vast experience of the organization that I am speaking from, and also my personal experience of almost 15 years of working with Majlis. So one is, I just want to say that it's so delightful to see that almost 30 participants are interested in this topic and are concerned with the issue of women's reproductive rights and conjugal relationships. So that gives us a lot of hope. Before I start, I just want to trace the issue of domestic violence, especially in the context of the feminist movement. As many of the speakers earlier would have mentioned to you, that early 80s was really the beginning of the autonomous women's movement in our country. And it started because of a very important case, which we call the Mathura rape case. And it's not like we didn't have a women's movement before that. We had very active women's movements even before that. Part of the political struggle, part of labor unions, women have always played a very, very important role. But the autonomous women's movement, as we call it today, started because of a case, I would say very similar in a way, that the hype or the attention that the Nirbhaya case generated, the Mathura case was as big as that. It didn't have social media, so it didn't receive that kind of publicity, but it was really big, with women from all walks of life coming out and saying enough is enough, and standing on streets and holding placards and asking for reform. One of the earliest reforms we got in 1983 was the amendment of the rape law, where we got few victories, I would say. One is that if women were raped within the power of authority, then onus of proof would be on the accused, because she did not have a space to fight it or to even resist it. So that was a really important change. The other change that we got in 1983 was that if the minimum punishment. So earlier, it was taken very lightly. If it was a case of rape, it was not taken very seriously, and then accused would always be left off, saying that he is a first time offender, he's never committed this before, he's very young, he's very old, and there were always reasons to reduce the punishment. So what the law changed to is that it was minimum, there was minimum punishment. So 1983, after that, if you see the trajectory of the women's movement, while they were working on many other areas, a very good focus was always on law. And every time an incident happened, there was a demand for law reform. So if you track the 80s, you will see that we had the family court set up. We had domestic violence was considered or first time recognized as a really serious offense because women were dying in their homes. Today, if you read papers, you keep reading about cases of rape, and it's covered a lot in media. At that time, early 1980s, you would see a young bride beautifully decked up on one side and an absolute charred body of a girl died in her home. And the reason given was stove burst. Later, that term came to be called dowry death. And it was such a big and serious issue that the parliament had to actually take into consideration, why are young brides dying in their homes? And they realized that women were burned to death because of dowry. At that time, it was called dowry. Today, we have changed the nomenclature and we call it domestic violence, because dowry is not the concern for women dying. It's so many other issues. It is because she's pretty, or because she's ugly, or because she cooks well, and because she doesn't cook well. And there can be 1,000 other reasons why women are killed, why women face domestic violence. But 1983, we got this amendment where 304B. So we always had this section called murder for everyone. But we realized the situation of women was unique, because when you die in your husband's home, then there are no witnesses, because everyone is part of the family who has committed this crime, and there is no evidence because all evidence is wiped out. So the 304B was brought in to say that if a woman dies in her husband's home within 7 years of marriage, then the onus of proof of proving that they did not kill her is on the husband. I mean, these are very serious, stringent laws, which India and the women's movement managed to procure, right? And then we got amendment in child marriage, we got PCP-NDT Act, we got numerous other laws. And as a lawyer and a feminist, I can tell you that India has one of the best laws for women and children. Protection, especially violence, we have one of the best laws. We are not lacking in laws. Like if I compare the Domestic Violence Act that India has, and I compare it to any other country, I will safely tell you that it is such a protective law, because it not only says stop violence, it also provides relief. It provides a relief for maintenance, it provides relief for residents, it provides a relief for all kinds of things that she needs. So one would really ask, we are sitting 42 years. I mean, Vibhuti is part of an active campaign, and I have seen her all through these years fight for this issue. So the question to ask is, what has changed? Has anything changed? What is the same? And I can tell you that, the statistic that we often use, 1 in 3 women face domestic violence. And for over a decade or more, that statistic has not changed. In fact, it has increased. We've not done a recent study, but if anyone had to do a recent study, you will realize that definitely this statistic has increased. In fact, in the COVID situation, for 2 years, women were locked up in their house. They had no hope of escape. There was nobody to come and rescue them. And the pandemic, we call it the shadow pandemic, but the kind of violence women faced during the COVID situation. Everyone faced, but women especially, because they were trapped in homes with no food, with no income, with everyone at home being, they had to become teachers and homemakers and workers and everything, which was a very, very difficult time. So let's go back to, we're talking about reproductive rights, we're talking about conjugal relationships, and what is the situation today? So if you talk about marriage and divorce, right, we have a lot of rights that women are given to women as soon as they are married. One of the basic rights is a right of residence. So as you know, that when women get married and they automatically get a right of residence in their husband's home. They don't get title, but they get a right to residence. With the right of residence, they have a right to maintenance. That means when you are married, it is the obligation of your spouse to maintain you, to maintain your children, and to maintain you in the standard that you are used to, or in the standard of living that they have, right? You have a right to live a life free of violence. No one can commit any violence on you, and that is not a right that is given to us by marriage or by law. It is a constitutional right. Every man, woman, and child of this country has a right to live a life free of violence. So these are very basic and fundamental rights that women have. However, this is not true. This is not the reality. And why is it not the reality? And why has law not managed to help women, access these rights or even live these rights? And I kind of see a gap in what law provides and the lives of women. And when I talk about women, people usually wonder whether I'm talking about a particular class, whether it's only rural women or it's only poor women. But when I speak, I actually speak across the segment, across the sector, because it's true that this happens even to rich women. It happens to all women of all religion, all caste. So it is not unique in that way to any one particular type of women. And what I see is that it's the way we raise our children, whether we do it ourselves or we do it through social pressure, or we do it through a larger community kind of patriarchal notion. But women are raised to be scared. And that's you and me. And we can all ask ourselves these questions, that how fearless are we? How brave, or how no, I wouldn't even call it brave. I mean, it doesn't require you to be brave to walk on the streets, right? It doesn't require you, it shouldn't require you to be brave to do what you want, to have freedom of movement, to have freedom of choice. But women are denied that. And they're denied that by putting this fear of the unknown. So, don't go out at night, you will be raped. Don't travel to work, or don't go to places of work. Don't travel, don't wear clothes of your choice. Don't look at people outside our family. It's constantly this layering of fear that is built on women. And the second most important thing is that we are conditioning girls that marriage is the be end and end all of everything. We're all geared towards this commitment to marriage. So you're raised with a belief that marriage is everything. And when you get married, then the whole conditioning is you better stay married by hook or by crook. You adjust, you manage, you give in, you submit, because saving this marriage is priority. And, I was very surprised, Vibhuti, when I was at National Commission of Women 2 days ago, and they were talking about, they're doing a research on domestic violence. And one of the things that came up is there is an overdose of this samjhauta or settlement, reconciliation, that women are pushed back into their homes. And the chief of the National Commission of Women actually says that family is paramount. Family is paramount and saving the marriage is paramount, and we have to do all things to save the marriage. And if that is the attitude, that we need to save the marriage at all costs, then how are we at the same breath asking that women should access their rights? There seems to be a disconnect. So at one level, we have the family courts, which are saying, come to us, we will protect your rights. We will give you the right to maintenance. We will give you the right to residence. We will give you a right to live a life free of violence. But women are so scared that if they take that step to access their rights, they will be shunned not only by their husbands, but also by their families, also by society, also by their friends. And that is the biggest barrier for women to access their rights. The first question that comes to mind is, if I go out and make any complaint, if I go out and access my rights that I deserve, that are my rights, that I have been violated, but if I go and do that, then the whole society will look at me as if to say, I have done something very wrong. I will not be accepted. And that, for me, what I notice time and again, even after immense violence. And when I talk about immense violence, I know domestic violence, talks about economic violence and verbal violence and emotional violence. But I cannot tell you, even in a city like Bombay, the amount of physical violence that women are facing. You're talking about broken heads, you're talking about broken bones, you're talking about bleeding, and in that situation, when you are telling this woman that, you have a right to file a criminal case, you have a right to ask for your reliefs under the civil law, but women are saying no. Because they're saying that if I do that, where will I go? What are my options? Where will I stay? Where will I eat? What will my children eat? And these are such critical questions in their minds that it stops them from taking a step. And a lot of times we find that the government is creating laws or creating schemes, but the schemes and the laws are not matching the demands of women. What are women asking, and what are the schemes and laws are addressing? I'll give you an example. When the we have these shelter homes which are being created, and the government imagines that there will be a shelter home, and when women face domestic violence, they will come to the shelter homes. But we did a study in Majlis where we kept asking women, you're facing domestic violence, we have this shelter home, will you go to this shelter home? Most women said no. And you know why they said no? They said no because, one is that shelter homes are like jails. Actually they're worse than jails, because shelter homes are places where they will get, they will all be put together, and they will be treated like worse than what they were treated in homes in terms of control. So you can't leave the shelter home, you can't dress the way you want, you can't use your mobile, you cannot live with your children, and there are 100 other restrictions. And what women are saying is that I may be facing domestic violence, but I still have a religious practice, I still have a way of eating, I still have a way of living, I still have my children that I want who should live with me. And women are saying that, you cannot just put us together to live in one place. That does not work. Just because I'm a domestic violence victim does not mean that I will give up on all these other things that are also important to me. And that's something the government has just not realized. The second important thing is women are saying that if I'm not in my husband's house, or if I'm not in my mother's house, then there is a big question on my character. That where was she? Where did she go? With whom did she go? And this is a fear that women have, that there will be an aspiration on their character, and hence they do not choose these shelter homes. So at one level, the government is thinking of how to make different shelter homes, more shelter homes. And at another level, nobody is using these shelter homes except women who are completely abandoned or extreme poverty who come and use these shelter homes. So there's a complete mismatch of what the problem is and what the solution is. When we come to the family courts, so the family courts was set up in 1984, and one of the prime objectives of the family court was that it will be a space, a safe space for women to come and present their problems and find resolution. However, it's really sad that, you know, this was an act that was drafted with a lot of love from the women's movement, each clause, each section. And then when it actually came into enactment, the first line in the Family Courts Act is, its primary objective is to save the family. Now, any act whose primary objective is to save the family, what can you imagine is happening in that court? So I'll give you an example. If I file a case for maintenance in the family court today, my first hearing will come after 1 year. 1 year. Do you know why? Because firstly, of course, the family courts are overburdened. So I get a date every 3 months. And in the first 3 dates, I am given counseling. I am starving. That's why I have come to the court for maintenance. But the first thing that the court will do is send me for counseling so that I can do joint counseling with my husband. And there is no order passed till almost a year when I go before the court. And that is when the court will start its procedure. So what is the demand of the women's movement was that women should get their right to maintenance. They should get it as soon as possible. They should be provided these services. But in the end, the court structure and the court grammar ensures that this whole process is just, you know, stretched to a limit which breaks women. And what Vibhuti rightly said is, you can make any number of laws to favor women, but the system finds a way to make it go against them. They just find a way, and even the best laws which are made for women will be used against them. So one of the biggest things that happens during counseling, so the counselor will say, you should go back to him. And she will say, but he has beaten me brutally, and he has done this and he has done that. And then she will say, oh, you don't want to go back to him. Why? Is there something that you are doing, or is there somebody you are seeing? That's why you don't want to go. Because the presumption is that, you know, you should just be going back. And if you're resisting going back, means you have an ulterior motive. And so a lot of women will succumb to that pressure because they don't want to be seen as, you know, that they have another relationship, or that their character is being assassinated. And so they succumb to this and they go back to the same domestic violence situation. But this time they go back weaker, because the husband can tell them that, you know, nobody can do anything to me. And see, even that you went to court and you got nothing. You had to come back crawling to me. And so the abuse then actually increases, and it's done in a more, in a more subtle way, that now he knows what can be proved. So he does it in a more, very manipulative way. The other thing we're seeing is, apart from delay, and I think everyone knows that delay is a huge, huge concern in the courts. The other thing we're seeing is the patriarchal attitude of judges towards women. There are, these don't even appear in judgments, but they are pronounced in court, where character of women is assassinated. The fact that she asked for maintenance She is shown as, somebody who is a gold digger, that she is, grabbing the money of her husband, and the way it is projected. And all these cases where women are legitimately going to access their rights are being termed as misuse. So I had this big question, because every time you hear this word, women are misusing the law, women are misusing the law. And I was very curious. So every time somebody says that, I take a lot of effort to understand what they mean by misuse. But actually what I realized is what they mean is use. What they're saying is, how dare you use? Like yesterday I was Vibhuti, in a session in Gujarat, your state, and I was talking to protection officers. And these are supposed to be the most critical agency to protect women. You know how much we invested in this whole idea. And he's looking at me and he's saying, Madam, lekin thoda sa to kuch zyada hi ho raha hai women ka, kuch theek nahi lag raha hai, thoda misuse hota hai. So I said, misuse matlab? So he says, misuse nahi, lekin matlab zara si baat, matlab 100% nahi hai. So I asked him, what does he mean by 100%? Like, does she have to die? Will that be 100%? Does she have to have broken bones or bleeding? Like, what according to you is 100%? And then I realized that they have a value system, which if you don't meet that requirement, then you're not a genuine case. So, you have to be doing all the work at home. You have to be working outside and earning the money. You have to look in a particular way. You take care of children in the perfect possible way. And unless you're doing all of this, and then he beats you, then okay, we'll see. So there is a notion of a good woman, a victim, as we call it. And anyone who falls out of that purview is seen as a misuse case. That she dared to file, that she dared to go against her husband, that she dared to stand up against her family, is called misuse. And that is the tragedy of 40 years of the women's movement, that it's tried its best. I would say that it's tried its best every decade to address the problem of violence against women. And I think the system is so harsh that every time we come up with a solution, the system finds a way to kind of crush you and not allow you to access your rights. So I will pause here. I have not addressed the issue of sexual violence. I think it requires a whole other session, because rape cases are different. They are tried in a different court and they have a different grammar. But just I would like you to leave you with a thought that we do cases of rape. And when we started our work, it's almost a decade of work that we have done. I have myself done almost 2,000 cases of rape in Mumbai city. And it was shocking. And it is shocking to know that 90% of our cases are of children. And the amount, the number of cases of rape by close family members, and when I say close family members, I mean fathers, brothers, uncles, grandfathers, is as high as 15%. So can you see that there is a link between domestic violence and sexual violence, because it's happening in the same home? They're not different and isolated. It's basically domestic violence layered with sexual violence, and everything is kept a secret within the family. So I'll pause here because Arun had told me that we need to keep at least 10 minutes for questions, and would be happy to hear from the participants what they think and what they believe, and if I can clear some doubts.
Thank you, Advocate D. Mello, for such an insightful session and taking out time and giving us valuable information. Now I would like to ask Professor Patel to give comment on what Advocate D. Mello said, right?
Yes, I think Advocate Audrey De Mello, it was really refreshing to listen to you. It felt like a witness seminar. You have been witness to women's movement And right from your childhood, from 1980, you have accompanied us in all the demonstrations, all the rallies, all the sit-ins, and also done primary data collection also, I remember, in Dharavi and so many places. So coming from you is such a lucid narrative that you gave, and the most appropriate examples that you gave, and also the way you unpacked misusing the law, very important. We have been hearing this since 1980. You still have a time. Your session is up to 4:30. So I would humbly request you to dwell on the recent MTB Act and the compulsory registration of sexual violence in case of when a girl child seeks an abortion, and under what concern the child sexual abuse, about which your work is extremely important. Your experience of Manodhairya scheme with the government of Maharashtra has also adopted, and the kind of budgetary allocation that one needs to make to deal with the gender-based violence, and the use of Nirbhaya Fund. In fact, non-utilization of Nirbhaya Fund and the misuse of Nirbhaya Fund. Yeah. Thank you.
So thank you, Vibhuti. Yes, I would love to talk about our work in sexual violence. We started our sexual violence work actually just right before Nirbhaya, about a year before Nirbhaya, and it started with a case that we were doing. It was right outside our office. This was a 4-year-old girl, and she was raped by a watchman of a school. And the first time that this case came to us, it was through the media actually, where we were hearing, remarks that a girl was raped in a school, and the rape is quote unquote, how people say alleged rape. What they mean was it's not true. And then all kinds of allegations on the mother. She's a single mother. She wants money from the school. And so we were very concerned that this is just in our backyard. So we approached her and we said, what's happening? And here was a lady, a single mother. Husband had deserted her. She was migrant. Her daughter, who was going to school, 4-year-old, was a first-time learner. And, I'll never forget the words of the mother. She says that school was the only place that she left her daughter alone, because she was so scared that something will happen to her daughter and the whole community would blame her, that she used to take, she says, mandir tak bhi main akeli nahi chhodti thi use. That was the kind of the way she would be with her daughter, be around her daughter, and school was the only place she left her alone. This girl was raped by a watchman, and the school, surprisingly, was protecting the watchman to an extent that they had got the best criminal lawyer to represent the watchman. And, the story goes that when she went to the police station, what the police did was, instead of registering an FIR, they called her to the school, bamboozled her, asked her all kinds of questions, and, to frighten her, and sent her back without registering an FIR. And the FIR got registered only and only because a very sensitive doctor, the girl was taken to the Sion hospital, and there a very sensitive doctor, when she examined her, she called the police station and ensured that they filed the FIR. What is surprising is that while the women's movement has been engaged with the issue of rape since 1983 and the campaign of policy, reform since 1983 over the last 40 years, we were shocked to see that actually there is no one who actually follows up a case in court. And the reason is that the criminal courts are a very shrouded in secrecy kind of space, right? You have in-camera trial, it's very closed door, nobody is allowed to attend, and so you don't get to see what happens inside. So we decided to follow up this case just so that we could support this victim, and we were shocked to see what happens inside the courtroom. There is absolutely no space for a victim, because the criminal justice system if you understand, it is a case of the state against the accused. So it will be a case of XYZ against the state of Maharashtra. The victim in this whole space is just a witness. She will be called in the beginning to give her statement at the police station, and she will be called next to give her witness evidence in court. And in between, there is no space for her. She doesn't know what is happening in the case. She doesn't know who is doing, all she knows is that something drastic has happened to her and she wants justice, but she doesn't even know where to find out if she has got that justice. So when we followed up the case, we realized that, Supreme Court time and again were passing a lot of good practices for victims, that the victim does not need to see the accused, that you cannot be asking past sexual history questions to the victim. You cannot be badgering the victim. If it's a child, then the victim, the questions have to be put through the court. We already had all of this because of the Sakshi guidelines, but nothing was followed. And I remember it was, our program is called Transforming Victims into Survivors. And one of the main agenda is that we will ensure dignity of the victim. We can't control outcome of the case because, conviction, acquittal is in the hands of the court, but we can definitely address dignity of the victim and ensuring best evidence. So we would say, no, you cannot move forward. You have to have the a screen between the accused and the victim. And the courts would laugh at us and say, ma'am, this is not high court, and you just have to make do. And we would say, no, we would not, because this is Sakshi guidelines, you have to do it. It took us a year and a half. We did get a conviction in the case in spite of the best criminal lawyers representing the accused. But also it was a time where we got two important legislations. One, because we got the POCSO Act 2012, which is Protection of Children from Sexual Offences Act. And two is Nirbhaya happened. And because Nirbhaya happened, we got the criminal law amendment. Now, these were two very, very important legislations in the rape law reform, because what it tried to do is, especially the child sexual offences law, it tried to put the child in the center, and it tried to provide the child with the best procedures so that the child would feel comfortable to report a case of sexual abuse and would feel comfortable, be made to feel comfortable both at police station, in the hospital, as well as in court. So a wonderful legislation, again, I would say, to protect children from sexual offenses. With the Nirbhaya case came the Nirbhaya Fund and 1,000 crore. And I remember at that time, the center running around in circles, trying to figure out where to put this money. And some of the suggestions that the money has been used for is cameras in buses. Because the center thought that if Nirbhaya was raped in a bus, then we need to put cameras in all buses. What the government did not realize is only 2% of cases of rape happen in public spaces. 98% of cases of rape happen inside closed doors. It happens by neighbors, it happens by, relationships, it happens by friends, it happens by teachers, it's all indoor. But because Nirbhaya happened in a bus, they said, let's put cameras in buses. Of course, today, none of those cameras work. Nobody cares whether they work or not. I don't know where that feed goes into, but that was one of the investments. The other investment was on street lights. Because somewhere, again, the government felt that if the area was lit up, then people would not get raped. But all of us who are women in this room know that you're constantly molested in public spaces, you're constantly molested in lit up areas, and lighting up of areas or day or night does not restrict the commitment of abuse. The third thing that the government did was they set up an agency called the One Stop Center. Today we have almost 600 one-stop centers in our country. Every district has a one-stop center. And what the one-stop center was hoping to do is they will have a counselor, a police officer, a medical officer, a legal aid officer, all sitting under one roof to be able to address the issue of any woman who comes to them. The other initiative that was started soon after Nirbhaya, and not because of Nirbhaya, because of a legislation which was passed way back in 1993, which was called the Delhi Domestic Workers case. So in that case, the Supreme Court had said that we need to provide compensation to victims of rape. You know, it's not enough that you file this case and, you know, somebody gets conviction, somebody gets acquittal, somebody goes to jail or doesn't go to jail. What about the victim? So today, with a lot of effort by the women's movement, with a lot of follow-up, we have a scheme called Compensation to Victims of Rape. And it is a center scheme which is supposed to provide compensation to victims of rape, but not only compensation, but all other support. Right? In Maharashtra, I remember in 2013, Maharashtra launched a unique scheme because at that time the center scheme was not available. Maharashtra launched a unique scheme which was called the Manodhairya scheme. And the Manodhairya scheme tried to give women at least up to 3 lakhs compensation. And that compensation is meant to be given at the start of the case. It does not wait for evidence. It's not supposed to wait for the trial, or it is not connected to conviction and acquittal. It is concentrated on the rehabilitation of the victim at the beginning of the case. Today, if you look at the Manodhairya scheme, sadly, it has become another place which is victimizing the victim. You know, where they were supposed to support the victim, where they were supposed to provide immediate compensation. Today, compensation is taking minimum 1 to 2 years. That too, a minimum sum of 30,000 is given, which was supposed to be given in 1 week's time, is now being given as late as after 2 or 3 years. And a victim is scrutinized and questioned and challenged and derogated in front of the entire committee. So a committee sits, a committee invites her, and then she is asked all kinds of questions, and then she is not even informed whether she has been granted the compensation or not. So a lot of women, after, you know, becoming exhausted with the process, just say, we don't need this compensation because it's too humiliating. So Manodhairya, and what I find is that a lot of people talk about misuse of Manodhairya. And that's really sad because, you know, I often ask people, how do you imagine that somebody is going to make a false case about rape, and for the sake of this measly compensation, which is not even awarded, and, you know, to ask a question that, do you know the scrutiny, both at the police and at the medical and at the courts, that a woman or a child has to go through before even being considered to file a case? And to think that somebody can come to the police station and say, talk about, you know, a very, very, very humiliating, interrogating, penetrative sexual assault, and do this for the sake of this measly 30,000 rupees, which is rarely given. So Manodhairya, with all its good intentions, has not reached the doorstep of victims. The other contentious issue is this issue of rape in families. So of all the cases of rape, rape by close family members is one of the most difficult cases to deal with. And why I say this is because I talked about domestic violence earlier, and I talked about what victims go through, even if they complain of domestic violence. But when it is domestic violence coupled with sexual violence, it becomes all the more difficult for women. Um, because like again, this whole secrecy that surrounds families, and this whole idea and notion that you cannot talk about anything that is happening within the family. When there is a fiduciary relationship, when the person is a financially dependent on this accused, then women have to tell their daughters to keep quiet. Women have to tell their daughters to bear it silently, because if they don't, then the person who is the provider will go to jail. So we've had so many cases where a young girl being raped in the family came out and told a teacher, told a caregiver, told somebody that they were facing rape by a family member. And when the mother was informed, we have seen cases where the mother has just taken the child and vanished, gone to the village, never to be found. The moment they realized, I've seen mothers beg and plead saying, please do not record this case. I will be thrown out by my family. They would say that I will correct the accused. I will, ensure it never happens again. We had a case where this girl, she was a family of 5 children. She was the eldest of the child, and she was all of 13. She had just got her periods, and her father started sexually abusing her. And she would tell her mother that, this is happening to me. And her mother would say, now there's a wedding in the family, we'll deal with it later. Now it's some exam, so we'll deal with it later. The mother even tried sending this little girl to live with her mother, in the hope that this husband would not have access to her, but he would go in the pretext to meet her at the grandmother's house, and he would rape her there. So in utter desperation, this young girl walks into the police station and complains about rape. The FIR gets recorded, and I remember this scene where the mother comes to the medical, because the child was taken to the medical, and she slaps her and she says, why did you have to do this? What is going to happen to our other 5 children? What are we going to eat? The daughter was put in a shelter home because everyone realized that if she stays with the mother, it will be very difficult. And then I remember the mother moving heaven and earth to get this man released on bail. And for that, the lawyer told the mother that the girl should come to court and say that I lied. So the mother would stand outside the Child Welfare Committee office to say, please give my daughter back to me. I will take care of her. I love my daughter. You have to give her back to me. And finally, the Child Welfare Committee, against our advice, released this girl to the mother. And the mother took her straight to court and made her say that she had filed a false case. And when you think of these situations, you think of the domestic violence the mother is facing herself. You think about the situation of the girl, and you think about what is going to happen to this family, and how are we going to resolve? How is street lights, cameras in buses, one-stop centers, how are any of these agencies going to address this young girl's problem? The other thing that we see is a lot of these cases are coming to light because they are pregnant. And I cannot tell you how difficult it is to see a 13-year-old, a 15-year-old body carrying a baby. Their stomachs are just this much. You can barely see a 6-month pregnancy because they are so tiny. They are so tiny and their stomachs are so tiny, and people say, how come it was not detected? Because nobody cares about them. Nobody cares whether they're getting their period. They anyway don't get their period because of malnutrition. So they don't even know when they're pregnant. They don't know what pregnancy means. And then it is discovered too late. So typically what would happen is that she's not getting her periods. She's got stomach pain. They go to a hospital and they discover that she's pregnant. Now the story starts. The moment it's discovered it's pregnancy, because we have, thank God, we have mandatory reporting, the doctors are mandated to report, right? And because doctors cannot hide a pregnancy, anything else they would have hidden. They cannot hide the pregnancy because there will be a MTP, there will be something, there will be a baby born at the end of it. So they feel compelled to report. Of course, the mother is crying, everyone is crying, saying, don't report, hum isko gaon leke jayenge, mat report karo, so much shame, so much something. But the doctors are mandated to report, and so the case gets recorded. Now, till a case is recorded, nobody knows who's the accused. Because mother must be knowing or family must be knowing, but they will silence this girl to say, don't say anything. Don't say anything. And when these girls, if they tell that, my uncle has been doing this to me, or so-and-so has been doing this to me, my father has been doing this to me, then these cases come to light, then the accused is arrested, and then the case follows. Right? Now, there is a lot of controversy going on about mandatory reporting. And the questions that are being asked, and I'm sure our later speaker, Dr. Amar Jesani, will address this whole issue about what is the role of doctors, what should doctors be doing? And it's a very important question, because should there be mandatory reporting? And the beauty about mandatory reporting is that it is applicable to every citizen of this country, not only doctors or teachers or nurses. It is applicable to you and to me. If we know a case of sexual abuse, child sexual abuse, we are mandated to report. And this is the first time something like this kind of law has come to our country. So everyone is scared of mandatory reporting, because if you do not mandatory report, it is a crime. So let's say my neighbor who is 14-year-old is pregnant and I do not report the case, then that is a crime against me. Because the whole idea of bringing child sexual offenses as a law was to deal with this whole secrecy about child sexual abuse. The child is small, they don't have agency, they can't do nothing. So that's why this law put the onus on everyone else, saying that you are mandated to report so that we can provide support and we can provide protection to this child. There has been a lot of controversy. It is 10 years. I have seen lots of fights and almost fist fights between doctors, and doctors are saying we should not be mandated to report. Teachers are saying we should not be mandated to report. NGOs are saying don't put it on us, put it on doctors and police. So everyone is trying to get out of this mandatory reporting. But I can tell you that cases of rape, penetrative sexual assault in Mumbai, before POCSO, before 2012, was approximately 150 cases per year. Today, because of mandatory reporting, we are recording 700 cases per year of penetrative sexual assault. And I would still say that this is the tip of the iceberg. It is only the cases where the girl is pregnant. It is only the cases where, the girl has, with lot of difficulty, come out and told the police that she's facing this sexual abuse, that a case gets recorded. In most cases, it's still hushed up. right? So when we think of mandatory reporting, I think we should tread very carefully. I was not a supporter of mandatory reporting. Instead, I opposed it a lot in 2012. And I was like, who is the government to tell us what we need to do? But when I meet victims, and from the cases that we deal with, I often wonder that without mandatory reporting, what would happen to this child? Where would she be? And what kind of person she would be? Would she be even alive? Because that's the kind of abuse that is happening in the homes. So my take on mandatory reporting is tread carefully and understand the nuances on the ground before you kind of make a decision whether mandatory reporting is good or not good or should go, and who should mandatory report. We need to really see who are these victims, how do these cases come to light, and what can we do to address this issue, right? The last point I think I want to address is consensual relationships. There's a lot of media coverage currently in the past few days about almost, the statistics say that 30% of cases of child sexual abuse, actually the children are in consenting relationships. Now, this is another very, very tricky ground, because who will decide? So, as you know, 18 is our age of consent, right? Earlier, our age of consent used to be 16. But universal age of child is 18. So even though women's movement protested, saying do not take the age of consent from 16 to 18, the government forced it. Child Protection of Children from Sexual Offences Act already decided 18. And in 2012, November, thankfully, because of Nirbhaya, criminal law got amended and age of consent even in IPC became 18. So now universal child is 18. Now, everyone is discussing what about consensual relationships? What is consensual relationships? The presumption is that there is a girl under 18 who's in love with a boy and she has voluntarily sex with him. And because the parents are opposing, a case gets recorded. That means he is not from this religion, or he is not from this caste, or he is not from our class, and so parents are opposing. But I want to say that that's not the universal cases. So let's say we are saying 30% of cases are in the so-called realm of consent, right? But all the cases are not this, that she's in love and then, it's something like this, that the parents are opposing. There are a sizable amount of cases where the girl had consent, she's 14, 15, she had consensual sex with a boy and she got pregnant. And she wanted to marry the boy because now her family is saying, you're married, marry the boy. The boy is saying, I don't want to marry you. And so she is left in the lurch. She's pregnant. Her family is not accepting her. The boy is not accepting her. And she walks into the police station to file a case. Would you put it in the category of consent? Because yes, she consented to the sex. But how are we going to protect her? Are we going to force the boy to marry her because that would be child marriage? Or what is the support we're going to provide her? So I want to leave you with a case that happened with Majlis just the other day, 2 days ago. It was a girl who was 16 years of age. She married, she got pregnant. She was studying in HR college. She got pregnant with a boy who was 7 years her senior. Not in college, he was just her neighbor. He was uneducated. He is uneducated. She fell in love. She was 16. She got pregnant. When she got pregnant, her family said, you have to get married. His family did not want her to get married to him, but they all threatened the boy, and there was a lot of pressure. And finally, the marriage happened. So ideally, this should have been a case of POXO, right? But it was not a case of POXO because everyone hid it and the marriage happened. If the marriage didn't happen, it would have been a POXO case because then she would have gone to the police station. The marriage happened. And after the marriage, the violence started. She had the first baby at 17. The violence was so abusive and so physical and so bad. Finally, she got pregnant the second time. And after she got pregnant, when her child died because of malnutrition, that was the poverty of that home. She's also malnutrition. And then because of the abuse, 2 days ago, she hung herself. Now you tell me, sexual violence, domestic violence, mandatory reporting, MTP, everything is in this case. And how are we working at resolving these issues? So I will again stop here. I think now I have gone over my time, but I'll hand it over to Vibhuti ma'am to take it over.
There's a question for you from Dr. Kevna Desai. Dr. Kevna Desai, can you unmute yourself and ask your question directly to Advocate Audrey Dumal?
Actually, that question was for Vibhuti ma'am, but I think Audrey can also answer this question. What would you see as a repercussion on women's sexual or reproductive rights if the age of marriage is raised to 21? It's a bill. I think it's not become an act still. But if it's 21, what repercussion would it have? On one hand, there are arguments saying that it will be obviously help her because she'll be 3 years older and maybe her decisions would be more rational or more informed. But on the other hand, we also know that the number of girls who are sexually active before 18 and 1/3 of them getting married before the age of 18. So what repercussion do you see for the age of consent being 21, age of marriage being 21?
Vibhuti ma'am, you want to answer that?
Yeah, I think there are three responses to that. One, the girls who are want to study, who want to build career, because I see many of these challenges I used to face as a teacher in SNDT Women's University. Even 2 days before the exam, if the boys' side says that we want marriage, and parents would not allow her to appear for exam, no. So if that kind of situation is there, then with this section of girls who want to assert themselves, who want to build career, who want to go for higher education, and who have some bargaining power within the family situation, and whose parents are law-abiding, who fear law, they will benefit. It's a very small section. Second section is that the traditional communities, they will continue, because now also when the age of consent is 18, we have 22% of girls, as per the NHFHS report, who are married as children in our country, and there are child mothers. Third section is that of which is going to happen in a big way, what Advocate Audrey talked to us about, consensual sexual relation. Adolescent boys and girls fall in love. In fact, you have Bollywood films where Kabutar Ja 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 and all those teenage love has been glorified, valorized. All our ministers and even presidents and all, they also organize private shows of such film of teenage love. So you, at one level, you are valorizing teenage love, but when it happens in actual life, you try to criminalize them. So I think there is a more and more criminalization of young boys because most of the laws, including Juvenile Justice Act, sees girl as a child in need of protection. It's all protective thing, no? Beti bachao and all. And a boy in conflict with law. Even during the pandemic, during social isolation, lockdown, everywhere it was even one-stop crisis center. They may say, "Aurton ko bachana hai." So they are in a seeing women who have to be protected and boys who have to be criminalized. So there is going to be more and more criminalization and brutalization of adolescent boys who are in consensual relationship. So I think these are the three patterns one sees emerging in even after the raising the age of marriage. This had happened in China immediately after revolution, in 1949, where because of the extremely brutal landlords in China, and where there also child marriage, child was married at the age of 8 and 10 and 9. I'm talking of pre-revolutionary China. And during the whole movement of Red Army and all, where the girls for the first time got respect as individuals, there was a popular acceptance by and the investment in education, and girls given new dreams of building the nation and all. In that political context, the community did not oppose raising of age, okay, and there was a popular support, because in fact, even in de facto, even after raising the age of marriage in China, girls were marrying at the age of 28 and 30 and these, because they had seen such a horrendous treatment of their mothers and grandmothers' generation, so that they saw these as a new liberation. No? But that is not the kind of political reality we are facing currently. What we see is a powerlessness, helplessness, hunger, and unemployment among most large majority of population. And there the question is that it is better to feed one less mouth. No? So even we have seen in Maharashtra, the most progressive state, also in Nandurbar district, within 1 year of 21-22, we had more than 6,500 girls who are married as children. So child marriages are increasing in all the socio-economically deprived sections in developing countries. That's the reality. There are comments in chat box, Audrey. It is about the infant rape and also.
Ma'am, Pratibha Mishra ji is already there, and I guess she will. Pratibha Mishra ji, can you unmute and ask your question directly?
Yeah. About the domestic workers and rape of domestic workers. Yeah. Pratibha ji, you can unmute yourself and speak. Hello. Are you there? Hazel Lindsay is also there, ma'am. Pratibha ji, are you asking? Please unmute yourself.
Okay, we also have Hazel ji.
Yeah, Hazel ji also there. Yeah.
You can unmute and ask.
Yeah, if you can unmute Miss Hazel, you can ask. Yeah.
We can go to
Hazel, yeah. Miss Hazel Lindsay, having a problem with my mic, she has written.
Okay, then she can type the question.
So Pratibha ji, can you unmute yourself? Are you able to unmute? Please give me a minute. Okay, okay. Yeah. So please unmute from your end and speak. Yeah.
Ritika ji, please go ahead.
Am I audible?
Yeah.
Yeah. Good evening, ma'am. Ma'am, thank you for your session. So my question to you would be, how can we make the structure of the current DV Act moving from transactional justice? So it is about right to maintenance, right to property, and we know how long these battles go in the family courts. So why don't we move to a more transitional justice approach? Like, why don't the courts ask, like, can we give any kind of support during that period before any interim maintenance comes on? Nothing about that is talked about. And in this particular climate where the center is actually supporting this restitution of conjugal rights, it's such a regressive clause that it shouldn't be there in the first place. So how do you view that? What are your thoughts on it?
So firstly, Pritika, I think, like Vibhuti also said, and even I said, you can make more and more and more schemes, and you can make more and more and more provisions. But if you ask me what is the answer, the answer is we need more feminist lawyers on the ground. Because unless you, me, and when I say lawyers, I don't mean people who have studied law. I mean people like you, me, who are doing this course should be there on the ground to support women, because whatever scheme we make, when it goes down into implementation, it becomes zero. Because nobody is monitoring it, no accountability. All these provisions you're talking about, right? Interim maintenance, providing support, DV Act has pre-litigation support that, even before she goes to court, she should be provided this, that, and the other. But who will ensure it's done? There is no zero accountability. Nobody's asking the questions. So I don't think that there is a need for any more. What there is a need is for all of us. And I'm so glad that PRI is doing these courses. And my hope is that, we need to be on the ground and we need to support women. And I have seen, it doesn't matter if you know the law, it doesn't matter if you don't know anything. If you are there strongly supporting one victim, you can ensure she gets justice, because everything is available. It's just about accessing it. But there is nobody to support her, nobody to guide her, nobody to, tell her, I'm with you and fight the system. And I think that's all we do at Majlis. It's not like, we are great lawyers or anything like that. We are just committed to women and we are telling them, we are here with you. And together we will fight this. And what was your next question? I think it was...
Ma'am, regarding the restitution of conjugal rights.
Yeah. So restitution of, did you all already have a lecture on restitution of conjugal rights? Or I think it's coming up tomorrow.
Yeah, it will be tomorrow by Saumya. Yeah.
Okay, what is my opinion on restitution? You know what is restitution of conjugal rights, right? For everyone's knowledge, it means that there is a provision in law where one partner, either the husband or the wife, can go to court and say, I want my spouse back. And conjugal, as you know, means sex. So I want my spouse back so that I can have sex with them. Quite a strange demand, but it is still there. And you'll be surprised that it is used by women much more than it is used by men. One. And it is a way that women try to go back to their husband's home when the husbands throw them out of their home. Right? So how it is used mostly is, a man will typically throw this woman out of her home. Woman does not want divorce. So what she will do is she will go to court and she will say, please put me back in my home and force my husband to take me back. But as you know, that our constitution is above any other law that can be made. So nobody can force anybody to do anything, right? Either this way or that way. Even if a husband demands that I want my wife back and the court says you have to take her back, she can still not go and nobody can do nothing about it. So, way back in 1883 or something, Rukma Bai, it's a very, very important landmark judgment. The courts ordered her to go back to her husband. And she said, you take my clothes, you take everything. I will walk naked, but I will not go back. So nobody can force anyone to go back. And it's quite ridiculous that it's there.
Thank you, ma'am. Thank you.
Thank you, ma'am.
If I may ask my question, the mic's working now.
Yes,
Yes, you can.
Sorry about that. Good afternoon, Advocate DeMillo and Professor Patel. Thank you so much for your presentation, Advocate DeMillo. It actually reminded me of why I first entered this field and why it's so important. So I'm a postdoctoral researcher and I specialize in the social legal aspects of violence against women and specifically looking at marital rape and dowry violence, which you also brought up. And I wanted to ask a question about something that comes up a lot in my research, which is the intersectional particularities of violence against women. So in your experience and in the experience of Majlis, are there any stark intersectional differences in reporting or access to justice that stand out, perhaps in terms of caste or socioeconomic class, education, employment, something else entirely? I was just curious to know.
Yeah, I've been thinking about it too. And, I don't think much as, in the past, one would say it was education, it was class, it was probably religion. For me, what comes to mind very strongly is that support of family. I find that whether it's lower, upper, doesn't matter. If there is support of family, natal family support, then women find it a little more easier to access their rights. That's one. The other thing I find is that when we talk about intersectionality, where, there is a prevalence of shame attached to, talking about violence. And therefore, if it's very lower class and if it's very high class, then the shame is relatively less. I would say in the lower class, it's the least. And when I say lower class, I mean really low, right? Where your life is open, your life is out in the open, everyone can see, the fights are in the open. For there, it's a little easier, but even there, they prefer to have this man around so that there's at least one man there, rather than everyone kind of them being single and then being accessed by everyone. So yeah, I think support would be the critical part of women making decisions to stand up against violence.
Thank you very much. It's very interesting.
Thank you, ma'am. I would like to ask you to give key takeaway remarks.
Audrey, your remarks.
I thought I spoke continuously. I don't know what, everything is my remark.
What are the takeaways of your lecture? And
my takeaway is exactly support a woman. Please, you don't need to know law. I swear to God, the Domestic Violence Act is 15 pages. The Child Sexual Offences Act is some 12 pages. You don't need to know more than that. Just read those 2 documents, get out, go on the field, find a woman and support her. That's my only, that's not key and every takeaway.
You don't have to even find them. You have to keep your eyes and ears and sensitivity at heart. That's it. Because everything is so rampant happening all around.
Yeah. And I think I must say this because it's a safe space. But for me, Vibhuti has been that support, and Vibhuti has, been able to provide that support to my family, because of which I am where I am. And I think that is just a wonderful example of what support can do to you.
You are where you are because of your determination and commitment to women's cause.
No, Vibhuti, I think without support, it would never have been like this. I mean, I look at so many other people who have so much potential, and without support, you can't.
Thank you so much, ma'am. Now I would like to invite our third expert for today's session, Dr. Amar J. Sani. Dr. J. Sani is independent researcher and teacher, bioethics and public health, editor, Indian Journal of Medical Ethics. Third topic is role of health workers in assisting survivors of sexual assault. Very warm welcome to you, sir, and over to you.
Hi, good afternoon to everybody. And Audrey is there. I have been listening to Audrey for quite some time now. Yeah. So it was a good session. Yeah. Well, are you able to see my PowerPoint?
Yes, sir.
Okay.
You can go full screen. Yes, it's
well. My topic is quite narrow. I'm going to focus on the health workers, or rather, even within that narrow focus, it is doctors, because I come from medicine, and I'm going to talk about what is the role that medicine and medical profession play in the sexual violence. But before I go into details of this, I thought I will comment on what Audrey, flagged it for me, is about mandatory reporting. And that's where I think the large number of doctors are perhaps protesting, saying that, well, we should not be made to do the mandatory reporting. And as she said, that it is a minefield. It's not very easy to decide whether we should have a mandatory reporting or not. But there are, as she said, some positive signals where number of cases were came to light simply because there was a mandatory reporting. Let me start with an experience. I was doing a review of a project which was on abortion, the researchers were looking at abortion in a city in South India, in a hospital. And there in the hospital, they found a girl who was about 15 years old, and she was getting abortion. Her grandmother had come to accompany her and given consent for her abortion. And the doctors carried out the abortion, and then they inserted a copper T. And that, they found that this without the consent and all, and she was bleeding and all. So they went, the researchers went to the ethics committee and said that this is what they saw, a very young girl, and being, we provided abortion in a public hospital, and then followed by that, they had inserted a copper T, and girl was crying all the time. A lawyer who was a human rights lawyer who was on the ethics committee was very angry, saying that this is a statutory rape. And I think this is the issue that bothers the medical profession. And saying that, well, it is not about the issue of consent at 18 years. But if you say that consent cannot be given before 18 years, then even a sexual activity with consent would become illegal. It will become statutory rape. And that's what happened in this case. And the lawyer who was in the ethics committee actually made it public, saying that the government hospital doctors are providing abortion without approaching the police for an FIR, because there was a statutory rape committed against this girl. Now, in this girl's case, it was a consented sexual intercourse with a boy who was 20 years old. But apart from that area, I think what is important is to understand that to terming a sexual relationship before age of 18 as a statutory rape could have a lot of consequences there. And when the girl herself was not ready to complain. And I think we also have a dilemma of deciding the agency of the person who has to file the complaint. If we give power to others to file the complaint, which will be a shortcut, saying that, well, since the agency, that is the girl who has experienced sexual violence, since she is not able to have her agency, the others will have to appropriate it and use it for the best interest of the girl. So if she doesn't do it, and if she doesn't want to file an FIR, and then it creates a lot of dilemma for anybody who is reporting. The other thing that I can say is that I remember in 1990s, I think around 99 or 2000, I was visiting US in one state. They had passed a law saying that anytime a doctor suspects that a woman is a victim of domestic violence, the woman goes with certain injuries or with certain kind of problems, and the doctor asks questions, and they find out that those things were because of the domestic violence, then it was mandatory reporting. That also created problem at that time. And what doctors have started doing at that time was that as soon as a woman with certain injuries came, they would tell the woman from the first point that, see, if you tell me that this injury is because of the domestic violence, then I will have to report it to the police. The same thing starts happening if you have a girl who is less than 18 years old and pregnant. Then the doctor may have to start the encounter saying that if you have come here because of the pregnancy or because of anything that is a consequence of sexual intercourse, then I will have to report it. So please decide whether you would like me to do that. So if you give that complaint, this is what is going to happen. Now this should be known to the victim or to the survivor. So I think that's where a lot of dilemma that comes for the medical professional about mandatory reporting. And mandatory reporting may be short-term useful, But in the long term, we are still failing to create structures, support structures, which can empower the underage person to take a genuine decision to report or not to report. So I think that's a very, very important issue that we need to keep it in mind. Now, coming to what I'm going to talk here, this is about, same thing is about sexual violence. Let me start with something about how prevalent is it. You know, I'm sure yesterday I couldn't join, but somebody must have given information on this, that there are a large number of women in India, they have experienced sexual violence in their lifetime, and there are also a large number of millions of women who are been victim of non-spousal sexual violence. And we also find that almost 2/3 or more than 2/3 of those who are victims of the non-spousal violence, sexual violence, they do not report. They don't go anywhere to get the support, like going to police or going to a lawyer to get something done. And only 1.5% actually go to the police station. That means underreporting of the sexual assault or sexual violence is extremely high. It has many, many reasons. I mean, there can be reasons related to society's ethos, which are the most important, because there is a huge stigma against a person who has been victimized in the sexual violence. So victim blaming and really devastation for the victim as well as the victim's family and the community. All of them are areas. Another is a lot of pessimism about the system actually helping you, and a series of such things. So the actual reporting of the violence is the tip of the iceberg. So keep this in mind, because when we talk about courts, when we talk about doctors examining victims and all, we must keep it in mind that we are touching a very, very small part where formal reporting of the rape or the sexual violence has taken place. That also should tell us that we need to create civil society organizations which are for the empowerment of women who have sexual violence. That means, where women are able to, take recourse to, rape support services for getting justice there, or providing psychosocial and physical treatment and support kind of organizations for the victims of the sexual violence. I think they are very, very important, because they will be able to tap and provide support to those who are not actually going to the formal system. And out of those women who are they are able to provide support, some of them may go and report to the police and fight for the justice. So this is what is very, very important, that we should keep it in mind, that any strategy that we have has to be broader than medicine and the law, because medicine and law will operate largely on the formal complaints by the women. Medicine still have a lot of cases coming where the formal complaint is not filed, but there are health problems, and so women may go for some support. These are the other statistics on it, which shows that there is a very low conviction rate. 1/4 is the conviction rate of the cases which are actually tried after the charge sheet is filed. So it's a very low conviction rate combined with very low reporting rate. So you can see how terrible is the situation, and why we need much broader support, and not just talking about reforms in law and medicine, but reform at the larger social level. Where the doctors come in the picture. Normally, what happens is that all the survivors who report to the police are invariably brought to the health system. Doctors and nurses examine them. In India, nurses still don't have a power to examine because we don't have nurse practitioners who are authorized to do it. But the doctors do it. But the doctors may be assisted by the nurses and others. Those who do not report to the police, they may also sometimes end up consulting doctors. If the health services, a good sensitive health service is available close by. If it is not, I mean, in India, the access to healthcare services itself is very low. But if there is such services available, in maybe in NGO sector, maybe in some good functional primary health center in the villages, or some good clinics or smaller hospitals in the government sector in the urban area. That is where these women go, or some private practitioners who are very sensitive. And they go for treatment of the injuries. They go for the prevention and treatment of genital and other infection like HIV infection or hepatitis and this and that. Or if they have become pregnant, they go for medical termination of the pregnancy. So this is a wide range of reason where women who have not brought a complaint to the police, that is FIR is not filed, and they still go to the services. But their number is still not in majority of all those women who face sexual assault. In that way, almost majority of the people do not have adequate access to the healthcare services in India. So it's a similar kind of situation there. But there are cases where they go. Once a person reports sexual violence to a doctor, the later when he or she is examining the person, then you are not only doing medical work, but you may also be doing a forensic work. That means whatever evidence that you collect may have some value in assisting the justice in case the woman at some stage would like to go to the police and fight for the justice. They can do even afterwards, after a few weeks, after a few months, and there are women who have done it after few years. When if there is a good medical record created when actually she had gone to the doctor, then it could be useful. If it is a bad medical record, of course, it will not be useful. It may go against her. So it's very, very important that doctor is professional enough to understand that at any stage when a woman who is not going to the police but still seeking health care, then he has to create a good do a good medical examination and record of it. Although let's look at how important it is. Sometimes a misconception, a kind of halo is created around the medical evidence to such an extent that the first thing that they do, a police will do it or the court will do, is that go to the doctor and get examined. Kind of, so as if that is going to be a kind of a magic wand which rod that is going to solve the problem and provide all the evidence to prosecute the accused. So although they keep doing it, it cannot on its own, the medical evidence cannot on its own prove that there was a sexual violence or rape. It can only prove that there were injuries. It can prove that there was a sexual intercourse, that means recent sexual intercourse, that kind of thing. It cannot do more than that. So its value is for corroborative evidence. And as you know that the rape or the sexual violence is such a private thing to happen that normally you don't have eyewitnesses, and that's how in this kind of cases it is the circumstantial evidence that is the most important, and the testimony of the victim. The victim has a very strong testimony saying that it was against my consent, then it will have a much greater value in the evidence than any other circumstantial evidence that you bring there. So it's a corroborative evidence. And then we have to, more important for the medicine is to ensure that this corroborative evidence does not play a negative role. And it at least provides support to the victim. So the LAP is a legal judgment to be made that it was against the wishes. It was a sex against the wishes of the consent of the person. The rest is a medical part, is to ensure that it does not victimize the victim, does not play a negative role, but has done enough homework to help the victim there and to have justice. Let me tell you how we started on this and my early experiences, because I was a medical student in 1970s. Thereafter, I didn't practice medicine, but the forensic medicine remained my area of interest because of a lot of work that I was doing in human rights field, as well as on reproductive health and the gender violence issues. So the issue was, that kept coming back to me. But my initial experience of the forensic medicine and later on when I was doing this work was very simple. That the discipline I saw at the time was very gender blind, very sexist, anti-women. And there is enough history. I think one of the background paper that I circulated from the Economic and Political Weekly makes it very, very clear that in the mid-19th century, when the colonial masters wrote the first book of jurisprudence, medical jurisprudence, they started with the idea that woman would be lying. So it's a whole obsession with a woman being a weak sex, a liar, and her virginity being very, very important, and that plays a great role in deciding whether she was raped or not. So all those things that the British or the colonial power brought in mid-19th century, that was still there when I was in medical school, and to an extent it is still there in the teaching and the textbooks of the forensic medicine. The other thing that I found among the forensic practitioners was that there was a massive domination of law and jurisprudence. Every time I met a forensic doctor, I tried to find out that, okay, you did MD in forensic medicine. After that, did you study anything? He said, yeah, I did. What? LLB. And what? LLM. You'll find that most of the MD forensic doctors also have law degrees. But when you try to find out that how much more you have studied about the forensic science, there's hardly any. Very, very few forensic doctors with PhD in the forensic science you'll get. A forensic medical science I'm talking about. There may be a few with also some amount of expertise in pathology. They might have, because these are the very two closely related disciplines. But what I found was that the whole discipline is so much obsessed with the law rather than looking at what it is doing and science of it. That everything you are doing in this, is it scientific or not, that is most important. And if you don't ask that question, and if you don't try to upgrade the skills of the way you are collecting forensic evidence and interpreting the forensic evidence, then you may end up doing injustice. And this is what has happened in India, that science is not at the forefront. And if science comes to the forefront, you'll find that ethics also immediately comes there, because you have to professionalize. Here, it is more of a lackey of law or lackey of the police. That is what the forensic medicine has become. And I think the profession has partly degraded itself by being so. I think it has given up some part of its independence from that system and be more science oriented. So a forensic doctor in India is invariably with a low degree and rarely with a higher qualification in forensic medical practice and science. And as you can see that the forensic textbooks, the Jai Singh Modi's one was the India-made textbook, and it is still there. It is one of the most popular, and there are many, many others. There is Parik's textbook also in that paper is mentioned. Way back in early 2000, we got textbooks of medicine reviewed, and the 1998 article of Dr. Lalitha D'Souza that I have circulated also does the critique of the forensic textbooks in India. So that was the Dr. Lalitha D'Souza initiative at Sehat in Mumbai in 1998 when she designed a protocol for the medical examination and forensic examination and for the evidence collection for the survivor. So she has to, if you read that paper of 1998 that was published in Indian Journal of Medical Ethics by Lalitha D'Souza, you'll find that she was battling at two fronts. She was trying to streamlining, looking at the scientific and medical and forensic aspects of the examination and evidence collection on one side. And on the other side, she was trying to ensure that it was done ethically, and the doctors were oriented to protect the human rights of the survivor rather than being a lackey of the police and what police said doing that. That was and if you read that paper carefully, you'll find that that is what she has tried to do, at two levels. So do it in scientific and professional manner. Don't overdo it. Do it only what is required. Do it in an ethical manner. And after doing it, when you go to the court or whatever you submit to the court, keep in mind the human rights of the survivor. I think these are the three major things that she has tried to argue there. And I think that remains an approach as far as I am concerned on the role of the health workers. When she did it, she created a protocol. She also created a kit so that nobody can have an excuse saying that, well, I didn't have certain things, so I did not do did not use certain protocols. So that was a very smart thing, and saying that, well, every department where it is carried out, it must have this kind of equipment available. And remember, before I go into all the challenges that she found, and I think they are very important, was that forensic work, that is doing medical examination or forensic examination of the survivor of the sexual violence is normally not done the forensic expert per se, because we have a few thousand forensic experts. They're not available everywhere. But yes, in a big hospital, they may be available and they can be consulted. But normally people go to the doctor. Right? You go to the primary health center doctor, you go to the big hospital doctors. Normally, because these are the women's cases, they normally go to obstetric and gynecology department, or if it is children, then they go to the pediatric department. So this is where you find that doctors who are not forensic doctors, they are doing forensic work, and they need to be trained in the forensic work. Otherwise, there are problems. And you cannot have forensic doctors sitting in every institution where these cases are taken. So that's how, and this is not only India, it's all over the world. That is how it is, because number of forensic doctors are limited at this level. So when the forensic work is being done by the doctor, it is very, very important to look at the kind of challenges they face. And when Lalitha D'Souza prepared her protocol, she organized a meeting of doctors. Most of half of them or 1/3 of them were forensic doctors, and some of them were leader in the profession. And what were the challenges at that time raised, and they still keep being debated? The first thing was that is the woman who is a survivor of sexual violence or rape is a patient of the doctor who is examining, because doctor is asked by the police to do the examination and say that, well, get all the evidence which are available, document them, send them to the laboratory, and make your report for the police and for use them. So should the doctor be treating the patient just like a client who is a force on them and not needing the client's or the patient's consent, and just do the forensic work of getting all the information about the assault, or one should also treat the woman as a patient and provide treatment, right? So there's the second case was there, that should the doctor also be providing treatment and counseling to the survivor? Yeah. So is it possible that in that kind of situation, the medical role of the doctor is not to be played by the doctor, or can it be neglected? I think this is a very, very important issue that were raised simply because the protocol that was prepared said that it is not just a survivor, but even survivor is brought by the police, is also your patient. So your ethical responsibility to the survivor remains same. Okay. And say that, well, even after collecting forensic evidence, you must ensure that the woman is provided treatment. That means, you do the preventive treatment for the HIV, preventive treatment for hepatitis, this, that, and all. And if there are injuries, treat them. And if there is a trauma, which is invariably be there, provide counseling and whatever that is required. So that was what the protocol said, that it has separate forms. The form for collecting forensic evidence and the form for collecting medical examination findings and providing treatment. The third problem that was encountered was what type of forensic evidence to collect. And that's where the major debate took place. And today, I think, hopefully, the debate is put to the rest. But that was the first time raised there, and there was a big fight. And that was about the finger testing. The finger testing, the entire thing had come from the source of two types. Both of them were highly sexist, anti-women sources. One said that the virginity is very important. And the second said that if a woman is used to sexual intercourse, and if she is of low moral standing, then she is more likely to lie or use some you try to frame somebody or something like this, right? So finger test was to find out whether there was a hymen or not there, whether it is there or not, if it is there, whether it is broken or not. And another was to find out how flexible was the vaginal wall and what was the size of the vaginal opening. All of this to find out whether she was used to sexual intercourse or not. Now, this has nothing to do with actually sexual assault, this test. Secondly, this test provides you nothing, because if the hymen is there or hymen is broken, it is either way proves nothing, because hymen can get broken for many, many other reasons. And it doesn't prove anything. Even when the hymen is intact, it doesn't prove that there was no sexual assault. Many times it happens that there is a sexual intercourse without the breaking of the hymen. So all those things are, the whole test was scientifically wrong. Now, this is the test that was introduced by our colonial masters in the jurisprudence book, and the courts and the lawyers and the defense lawyers and have lapped it up. Is no longer there in those countries. British brought it, but if you go to the Britain and find out what kind of forensic work they do, they will never do finger testing and never do the testing of virginity for this purpose. So this is scientifically considered to be totally obsolete and useless. So this was another area where there was a big fight, on this, and it was well known that. By doing this test, which are obsolete, they were providing support actually to the defense, that is the accused, who will try to bring a past history of the women's sexuality in the discussion, and show her as a low moral standing, and try to show that her claim that there was no consent for sexual sex was based on wrong premise, or that she was lying or something like that. It's very, very important area where medicine was becoming complicit with the opposite, and that's where the first initiative in 1998 put the foot down, saying that this is totally useless. This should not be done. On the contrary, the doctor should be providing counseling support and all. That is very, very important thing that happened there. And the last thing where a lot of debate took place was about the consent. 3 levels of consent. The first was a level where you say that, can I collect the, forensic evidence? That means getting all the information about the injuries, also information about the private parts and the condition, information, taking specimens and that kind of stuff. Second is that, can this forensic evidence you collected with the consent? There should be another consent which says that, well, we hand over this forensic evidence that is collected to the police, right? In India, it is almost considered like that. But can doctor do the forensic examination when the woman is not brought by the police? Woman has come on her own. She says that I want to get examined. You collect all the forensic evidences, keep them. Woman says that don't send it. I will decide when to send them to the police. Is it permissible? No, this is an issue that we need to ask. I think many countries have given them doctor right to collect the information, but not a right to give it to police unless the woman says yes. And the third one is the doing a regular medical examination and providing treatment, and both physical treatment as well as mental health support. And all these things are very important. And the law may not be very, very kind to the woman and the doctor who gives the consent the most important place in the entire process. It's very important. But the protocol that was developed in 1998 and the subsequently being talked about is that at all these 3 stages, you require consenting of the woman, because woman is the one who decides whether she wants to file a case or not, and she decides whether all the evidences should go there, or she just wants to fight on her own testimony. That is, I think, judgment is to be made by her and not by any other party. When doctors can explain whether it is how it is going to be useful to have those evidences sent, but nothing beyond that the doctors can do. Doctors have a very, very limited role of assisting and helping and creating the evidence in a most impartial manner as possible, so that the justice system can use it. Nothing beyond that. But that how it should go there should be the right of the woman. That is, I think, the strong human rights perspective here. Now, coming to the last few slides, I will go through very quickly. Here are the dual obligations of the doctor. So on one hand, a woman comes with a complaint of sexual violence, and you see that she is disturbed. So you have a clear duties as a doctor to protect the patient's rights. On the other hand, you as a responsible citizen, and at the same time, there may be laws, putting a certain role on the doctor when they examine this kind of patient, and to provide assistance to justice system. So, as the doctor who's the primary duty is to protect the best interests of the patient. On the other hand, has a dual or a conflicting duty to be a neutral provider of assistance to the justice system. And that's where a lot of what we call dual loyalty or conflicting loyalty comes. And that's where the doctor will have to use the consent of the woman as a main justification for what they are doing. The doctors doing forensic duty, they experience this kind of conflict the most. There are many, many other areas where this conflict comes. For instance, a patient comes and says that do my medical examination because I want to buy an insurance. And the findings that are there, that the doctor is supposed to send it to the insurance company. The doctor knows that if he discovers certain diseases, the patient will not get coverage of those diseases. This is another dual loyalty conflict, that you are playing a role and as an intermediary, and that is that is creating dual loyalty problem. So this complete fidelity to the patient and providing assistance to criminal justice system may have a conflicting issue as far as the doctors are concerned. The other is that most examinations that you carry out, even medical examinations, they may have may have to be interpreted in the context of the kind of history that the woman provides, and that's where a lot of issues may come up, because even small injuries which you have noted down can be twisted in the court of law during the proceeding if you have forgotten about how what kind of evidentiary value that. So doctor has to be very, very strong, and because there are ambiguities here, it becomes very, very important for the doctor to, when they do the examination and provide care to the survivors, to have a very good rapport and understanding, and they know that they have taken consent after providing a full range of information. Now, these are 9 ethical guidelines of the British Medical Association, which may be some of you may find it useful, because I consider that when you say that doctor has got certain ethical obligation, its meaning is that these ethical obligations are nothing but respecting the rights of the client or the patient. So if these are the obligations doctors fulfill, then they are also fulfilling the or supporting the rights of the survivor. First thing is to carefully explain, that what is the role of a doctor doing forensic examination. This woman should know, right? So this is I'm playing dual role. I am also your doctor, and I am also doing forensic examination. And the evidence that I collect may provide you support or may not provide you support. And that's how the doctor's neutrality at this level is very, very important, and the role the doctor is playing is understood by the woman properly. Doctor should not insist on being able to examine patients without securing officers being within the hearing. This is another very important thing, in not only in the rape cases, but also in all human rights cases, even torture cases, which are brought to the doctor. The policeman normally remains present there, or policewoman normally remains present there. This is not acceptable. The only person who remains present there is the one who is called by the woman herself, or a nurse, or a female assistant when a woman is being examined. Police person can remain at a far away. They may not have visual visual privacy, because police wants to see that she is being examined and she is not running away or something like that. Or doctor may be examining even the culprit, the person who has done the rape, because doctor ends up examining both of them, or different doctors do the examination of them. But it is very, very important that the police officer is not at the hearing distance of the woman who is being examined. Before any information is volunteered, doctor should state explicitly the part of their role is to collect evidence for the prosecution. What I'm going to do 1, 2, 3, 4, 5 things, which is all forensic, which is collection of the evidence, which is for the justice system. And the other thing that I'm going to do is to understand your health condition and you provide you treatment. Both these things should be explained very well. Doctors should explain that in addition to providing forensic evidence, they are required to provide to the police any information obtained during the examination, which might affect the outcome of the case. So this means the woman may not have a full confidentiality of her medical record. The doctor clears, right? Explaining means seeking consent. That is number 5. That is you explain all these things, and as I was telling you, that the 3 levels of consent needs to be obtained from the victim, so that there is a first consent is for collecting forensic evidence, second is for doing medical examination and medical care, and third is disclosure of the record or the evidence that is collected to the justice system, that is police here, or the forensic laboratory. So while you are, as a doctor, when you are doing it, you should consciously separate out forensic evidence, any information obtained that likely to affect the outcome of the case, which normally doctor notes down as a note, and when they go to the court, when they are giving evidence, they may have to, depend on those notes to explain. Any information not germane to the case, but provided solely in the therapeutic context, that is for the treatment of the woman. A statement should be provided for the police giving all forensic evidence and any other information obtained or that is likely to affect the outcome of the case. If police requests further information about medical examination that was not included in the report, then doctor may be required to provide it. If patient refuses to consent or consent to only partial disclosure, the doctor should abide by the decision unless exceptionally doing so is going to have a massive miscarriage of justice or effect on the third party. That means the consent becomes very, very important even in this case. The problem, I'm sure, if Audrey is still around, she will say that, well, woman is normally so disturbed at the time that she may not have really good condition to understand the information and provide the consent. Now that problem is there, but that does not mean that the doctor should not should stop respecting a woman who is disturbed and become patriarch, and start behaving paternalistically. So this is broadly what I would say about the kind of guidance. This is a very broad guidance, but there is the guidance, ethical guidance that doctors should be following, and I already explained to you certain scientific aspect about what they should be doing or should not be doing. So based on this, if you have any question, I think this is over, and these are the references. I'll send out PowerPoint, and you can definitely go through these references. If you don't find any of them, please write to me, and I'll send you whatever things that you need. Yeah. So let me stop sharing so that.
Thank you, Dr.
Yeah.
Jindal, for an enriching session and giving us valuable information. I would like Professor Patel to comment on what Dr. Jishwani just said.
Hello. Are there any questions?
No, ma'am.
Okay. So can we sum up the session?
Yeah, ma'am, there's one question.
Yeah. Okay.
What role does the religion, gender, caste, class, location of the doctor play in reporting of sexual violence by a victim? Can it be a hindrance for a survivor's access to medical support?
Well, this is a very important area. There are 2 levels here, I would say. When I was a medical student, most of the doctors were men. Almost 70-75% of the doctors were men. And even in the obstetric and gynecology department, almost 70% of the doctors used to be men. Now the ratio is, as far as man-women gender ratio is concerned, has to an extent reverse, in the sense that there is a feminization of the medical profession. So there are a large number of women doctors now. So we cannot say that women doctors are not available. Even if you are talking about, say, Ayush or Indian systems of medicine, the majority doctors there are women. So there has to be a provision of women doctor, because if a man is there is a hesitation, particularly immediately after sexual assault. It's like any other area where somebody assaults you, and the identity of that person actually becomes a point of revulsion for the victim. So that's how the sexual assault by man will make a woman very cagey about interacting with the man. So when man as a counselor of the torture survivor is a very problematic area here, unless of course there are because now we are not talking about sexual assault only in terms of men and women, but with LGBTQ and all of them being there. So you have men having sex with men, women having sex with women, all of them are included, trans gender people and all of them. So you require a more conducive gender environment where the victim is able to identify with the gender of the provider, the doctor, where she will be or he will be or they will be very comfortable explaining and talking to them. The other part is the other social aspects, particularly caste and religion. Now, caste was always all pervading, in our system, where it was assumed that in medical environment it doesn't play a role, but that is not so. Very grossly, or sometimes in a very sophisticated manner, the prejudices of the doctor gets manifested, and the doctors always believed that those who are, say, working women, they can bear more pain, and that is why you will see that recently there was a reporting that doctors did tubectomy on women without using anesthesia. Why? Because they were coming from peasantry. They were all poor women, laborer women, and it is just arbitrarily assumed that they can have a very high threshold for pain, and so you can cause pain to them without feeling any bad. That was again you'll find in obstetric ward, where labor room, where a woman complaining who is a poor woman complaining of pain during the childbirth will be neglected, but an upper middle class woman, where pain management will be done much better, because her complaint of pain will be taken into account. So yes, that is also very important. And the not having women plus having women from the depressed strata are very important there, because large number of unreported and reported rapes are suffered by these women. They are from this strata. So not having enough number of women from the lower caste and tribal as well as minority is a very troubling aspect, and that does have a bearing. The last point I make, and I just made it recently when there was National Bioethics Conference, 9th National Bioethics Conference on Mental Health Ethics. I said that, well, if you go to US and go through the literature, medical literature from US, you'll find a huge amount of literature on the prejudices against the blacks or the racism of the providers in the US health system. But we hardly have any literature, good studies done to show that, how prejudicial on the basis of religion, caste, and gender, the doctors in India are. We do not have enough, and there is not enough sensitization of the doctors on this. And that does not mean that women doctors are always sensitive doctors. They may not be unless they are sensitized. So irrespective of gender, all of them need more sensitization on this part. Otherwise, just having a Dalit doctor or a woman doctor or a Muslim doctor is not going to be sufficient. So you require their representation because that identity will help in reducing the anxiety of the survivor and being more ready to talk. But at the same time, the doctor from any background will require more sensitization training, because in the obstetric and gynecology, I have seen that sometimes the insensitivity is across the gender, and that is true also, I think, in many other professional fields. And so we need to emphasize that all of them require some amount of sensitization training there, and they need to understand. They need to not be just gender sensitive, but also culturally sensitive. They should know, the culture and the context in which lower caste, the minorities, and the women survive in this country. So yes, I think it is very, very important.
Yeah. Yes.
Thank you, sir. I guess, Nana, you can take over from here.
I would like Professor Vibhuti Patel to give the concluding remark for today's session.
I think Ms. Pratibha, Dr. Pratibha Mishra has also written in a comment that we can have this in National Education Policy 2020. So I think Dr. Jisani has brought in very important aspect of role of health workers, whether they are doctors or nurses or health administration or the healthcare foot soldiers in the healthcare system. They have a very important role to play in assisting the survivors of sexual violence. We have seen, even in cases where, as women's organizations also, we have seen that sensitized nurses or sensitized ASHA workers, Anganwadi workers, they have been very supportive. In fact, the recent study by Makam and also by the GID, Ajivika study has also shown the heroic role that women played during the lockdown by supporting the survivors of domestic violence, survivors of sexual violence. So I think he highlighted 4 important aspects. One is about the mindset of the doctors. They also are the carriers of the same kind of prejudices based on caste, class. So the intersectional vulnerabilities of patient we need to take care of. Payal Tadvi's case is a glaring example which has sensitized the medical profession, that even an MD doctor, because she happened to be from a religious minority community and tribal community, how she was tortured by her 3 colleagues. They were all doing post-graduation, and it became a very important, and she was driven to suicide because of the mental harassment and the continuous dehumanizing statements and degrading statements that were made against her. So I think that is one important concept. Second one is that the patriarchal mindset of the medical profession, and so many examples he gave about how the forensic science or the way medical examination is conducted, that also instead of focusing on circumstantial evidences, they would focus on the past sexual history or the 2-finger test, which is so outlawed. In fact, even after outlawing 2-finger test, and Sehat has also prepared the kit which has been adopted by Ministry of Health, hardly 10 states in India are using the new form. They are still continuing with the old form, which also has a also has an item called 2-finger test. So we have a lot in terms of gender in medical education. Intensive training is required for the both medical students as well as the medical professionals on gender issues. And the question of consent, very important ethical concern that we have, and also the dilemma, the complexity of this consent and also the treatment which needs to be gender sensitive. My presentation about the reproductive rights of women in India that encapsulated the efforts of the women's organization, women's feminist movement globally, nationally, regionally, and locally over last 50 years. And all the issues of women's myths about menstruation, to nutrition issue, to the question of mental and physical health, reproductive health, all these issues have been taken up by the women's movement. And that's why we see that whether it was the ICPD, International Convention on Population and Development, a Beijing Platform for Action, CEDAW, everywhere Indian women's movement has played a pivotal role in bringing up the reproductive rights issue. And the reproductive rights are human rights, and it's a right-based approach with which they are functioning. Audrey's presentation was extremely important in terms of what the law gives. And she said that, yes, right from constitution to the series of legal reforms we have had post 1980. She started with the Mathura rape case and how the new sensitization came. And though it was a nationwide agitation against rape, demanding changes in the antiquated rape law and also demanding justice for Mathura, it was not backed by social media, but it was an extremely important, it was a watershed moment so far as the Indian women's rights against the movement against the sexual violence. And she also said the painful reality that one faces while dealing with the criminal justice system, the whole attitude of the police, attitude of the counselors, attitude of the legal system, and the predicament of the survivor of sexual violence. What we need is a more hand-holding. Her experiences were driven from her personal involvement in the anti-rape campaign. And even as a child, she was the youngest girl in the whole movement in 1980. And also the work which Majlis has done, for which she has provided support and handled the cases of over 2,000 in last 30 years. So I think today we had a very rewarding session. We started with the overall campaign for reproductive autonomy and reproductive rights of women, and the campaign fight against reproductive control. Then we came to the sexual violence and the different kind of institutional support system that we have, critical evaluation of that. She said that what the things are there are progressive laws, but what women can access. So the gap between what is there and what can be accessed by we need to bridge by the community support, by the support and solidarity. And Dr. Jisani's lecture is about, as a medical professional, what kind of reforms that we need in the medical system, medical education, and this kind of healthcare services that are provided to the survivor of violence. So I think it today we have thoroughly enjoyed, and the questions asked by the participants, they were also extremely sharp and focused.
Vibhuti, before you finish,
yeah,
I think there is a question on, which is very important from Pritika.
Can unmute.
Yeah,
Pritika
please
ji,
go ahead.
If you don't mind a couple of minutes, can I take it?
Yeah,
Yes.
let her
I think this is
and ask you directly.
Yeah, this is a very important question, which says that what happens in the marital rape, where can there be any kind of forensic evidence for the marital rape? I think that's what I was saying in my presentation, that we need to be very, very conscious about what are the limitations of the medical evidence in that, because rape is not diagnosis. Rape is actually a legal judgment, where you have to establish that there was a sexual intercourse without the consent of the spouse. What I was talking was mostly about the non-spousal, sexual violence. In the spousal sexual violence, it is going to be very, very difficult here, where immediate, what can you find out? As a doctor, you can find out if there was a recent sexual intercourse, and the intercourse was with the husband. Right? So if you have a sperm taken and examined, you can do genetic analysis and say that yes, it is the husband's. So there was a sexual intercourse, which is a normal thing, which can be taken as a normal thing between husband and wife. It only proves that yes, it was. If husband says that no, in last 6 months I never had any sexual intercourse with my wife, then you can prove it wrong by having this forensic evidence. But if the husband say yes, we are having regular sexual intercourse, then it is not possible to prove it as a rape. The rape decision, as I said, cannot be a medical diagnosis. Medicine only diagnoses whether there was a intercourse or not. If that also within certain time span, if woman reports that without changing her garment, because there may be garment may also have evidence available. That is if what they say is that when there is a post sexual intercourse, there may be some injuries. If there are injuries, which is possible in say 30% cases, 40% cases, not all. It cannot be taken as a diagnostic, but it can be taken as one of the evidence as in support, in addition to the intercourse, saying that yes, there was a injury too. It has nothing to do with whether woman registered or not registered. It is the aggression of the person who did it that is, I think, very, very important, which may leave certain marks, and that can be reported. So yes, there is a very, very limited. I remember the first time long back in 1996 or 1997, when I was doing examination of medical evidence presented in the court. I got some material from Indira Jaising, the advocate. That was the time when there was several rape cases reported from Jalgaon. It was well known as Jalgaon rape case, where the women who were raped, they came forward to talk about their rape after a few years of the rape. It's not immediately. And Dr. Advocate Jaising was very, very surprised when she found that the first thing that police did when these women went with the complaint of rape was to send them to doctor. Now, what is doctor going to find out after several years of that? Well, then the doctors did this finger testing, and the accused tried to prove that these women were loose character. They were sleeping with all kind of men, and some were married. And it was not one woman; multiple women were raped there, right? And so all kind of things were brought into the picture because doctors did the medical examination when there was no role for the medical examination there. So because you cannot find out anything, there. What happens is that many times women don't go to the police, but they don't go to the doctor. So as I said, that 1 day, 5 days after rape, and then they tell them, and the doctor make a medical record, which is not sent to the police because there is no police complaint made, and there is no mandatory reporting by the doctor. Doctor just put down that medical record after a few years can be used to show that yes, she had talked about it. She had gone to the doctor to get the preventive vaccine or prophylactic tablets, because she was afraid that rapist might have passed certain infection to her, or she had become pregnant and then she had looked for abortion the doctor has provided. So that is where that medical record can be used after 5 years when she actually wants to come out. When to come out is a woman's choice. It's not the choice of the doctor or choice of anybody else. And if she comes out and all these records are there, they can be used as a part to support her that yes, she had problem. She had confided it to some people who have created record of it, that this is what she had confided, that she is not lying. So this is but that is all of them are circumstantial evidence. Whether it will convince the court or not, that only lawyer and the courts can tell. What doctor can do is just to assist the person who needs the assistance. This is how it is. Okay.
I think, but DV Act, Protection of Women from Domestic Violence Act, talks about 5 types of violence: physical violence, sexual violence, economic violence, psychological violence, and emotional violence. So women have used marital rape, like the sexual violence. Under that also, women have filed cases. And if there are bodily injuries and all, then they have been able to access the justice system. No? So that provision, so because there is no law on marital rape, but we have a DV Act, which women have been accessing currently. Yeah.
Thank you, Dr. G. Sani, for answering the question, and Professor Patel for the concluding remark. As we have come to the end of day 2 of a 3-day immersive online legal awareness and certificate training program on reproductive and conjugal rights of women in India, I, Naina Agarwal, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, Gender Impact Study Center, GISC, New Delhi. We are grateful to our expert for the day 2 of this online certificate training program, Professor Vibhuti Patel, Advocate Audrey D. Mello, Dr. Amar J. Sani, and to Professor Vibhuti Patel for chairing the session. We thank all of our participants who have raised pertinent questions and actively participate into today's deliberation. We look forward to welcoming you on 24th December at 2:30 p.m. for our last day of this training course by distinguished experts, Professor Dr. Saumya Uma, Advocate Dr. Albertina Almeida, Advocate Mrunalini Deshmukh. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good day and thank you.
Thank you, Naina. And thank you, Fizan.